Good afternoon, everyone, and welcome to our last session for the CSS lecture series, our panel on gender and Indigenous people's rights. This panel is co-organized by the CSS and the Kasarian Gender Studies program of UP Baguio as part of two celebrations, the Indigenous Peoples Month of October and the 24th anniversary of IPRA and the UP Pride 2021. I'm Karin Kojasi Bangsoy. I teach political science at the CSS, and I'm also the current convener of UPB Kasarian, and I will be your moderator for this afternoon. With me as co-moderators are Prof. Olive Mendoza of the Department of History and Philosophy and Ms. Joy Paginago, staff of Kasarian. So our panel this afternoon will examine gender and Indigenous people's rights from legal, activist, advocate, and academic perspectives. May we remind our presenters you have 30 minutes to present, and we'll be prompting you through the chat box about your time. So to our audience, feel free to type in your questions through the chat box or in the comments on our Facebook live stream, and we will get to them through the open forum. So without further ado, let us begin with our first speaker. So going first, just switching our lineup a bit due to some technical difficulties now, but we are starting with the viewpoint of community experiences on IP and gender rights. So speaking on community experiences and advocating for IP and gender rights, we have Judy PASIMIO, a Filipina, a mother, activist, and a woman human rights advocate who works in solidarity with the Indigenous women. Her work on land rights, access to natural resources, and Indigenous rights started when she worked as a campaigner with LRC. She also became the Luzon Regional Coordinator and later served as the Executive Director of Legal Rights and Natural Resources Center, whose main partners were Indigenous peoples struggling for their right to self-determination from 2007 to 2011. She's currently the overall coordinator of LILAC, Purple Action for Indigenous Women's Rights. At LILAC, she has led the organizing of Indigenous women's gatherings, both at the regional and national levels. These provide the compass of LILAC's strategic support to their struggles. So without further ado, our first speaker, Ma'am Judy PASIMIO.
Hi, Karin. Magandang hapon sa ating lahat. I'm honored and actually quite nervous to be part of this panel who are experts in topics that they are speaking on. As for me, I'm going to speak as a woman human rights activist, as a feminist, and as a member of Lila Collective, who have had its fair share of community experiences in advocating for IP rights and Indigenous women's rights. Along the way, I will like to share my few reflections on this journey. After I graduated from Diliman, I went straight to work with LRC, or the Legal Rights and Natural Resources Center. LRC is a legal and policy research and advocacy organization, primarily working with Indigenous peoples, with Attorney Marvic Leonen as one of its founding members. Hindi po si Larry Gadon, as one of the posts in Marcus Junior pages, which claimed that Larry Gadon was the founder of LRC and served as a dean of UP College of Law. But I'm digressing. At that time, I was part of the team of LRC who went up to Cordillera for the discussions on DAW2, or the Department of Environment and Natural Resources Administrative Order Number 2, Series of 1993, which provided for the issuance of CALCs, or Certificate of Ancestral Land Claims, and Certificate of Ancestral Domain Claims, as one of the land tenure instruments for Indigenous peoples. This was the precursor of IPRA, or the Indigenous Peoples' Rights Act. And I would like to share three remarkable instances. First, when we went to Sagada, and I was with Attorney Leonen, it was a crisp morning and we met with elders. The meeting was held in Dakay. And as the only woman, a young woman at that, I was literally out of the circle. It was both a humbling experience, but also a very disempowering one. Later on, when I would be traveling alone to Sagada to meet with a few leaders to follow up on cases or campaigns, I would always be met with men leaders. It was only later that I would meet Kankanay women from Sagada who are leaders of progressive organizations in Baguio. My second story is when we were in Bontoc. It was my first time then. In the evening, I sat with the women of the house, in the house I was staying in. After dinner, our conversation took us to stories of ulog. Then we started talking about sexuality, women's bodies, and eventually discussing rape and if women or wives can say no to their husbands. The women were engaged, talking animatedly. But in the next morning, while waiting for the second day of the formal meeting in the municipal town hall, where mostly men were in attendance, I was told by one of the women we were traveling with, why were you discussing these things with the women? Were you not here to talk about land problems or Dao too? Then there was also this story, the last one, the time that we went to Barangay Niba, Tingtinglayan. This time it was a big group from Baguio and Manila. We were there to witness the inauguration of a micro hydro dam. It was meant to run a small mechanical knife sharpening, like bolo, and bigger knives, I don't know what you call it, but also to run a radio transistor and an incandescent light bulb per household. Lights out would be at around 6 or 7 p.m. When talking to the women later in the evening, they were saying that it would have been better for them to have more time with the lights on so that they could do more chores, and the children would have time to study and do their homework in better light. And so why not? I asked them. They just shrugged their shoulders. These were the three incidences that made me personally think about indigenous women and their own voices. If we were to sit together in a circle like the pie or meet in a big town hall, what would they say? What would be they thinking about? What would they share? These were the questions that nagged me and went with me as I visited and worked with other indigenous communities all the way to Mindanao through the years. We met and worked with Team Wise, Datus, Bongflong, male leaders as we talked about land issues against logging legalized by the different forest management agreements by the DNR, the Mount Apo geothermal project, the environmental impact assessment, and the lack of consultations with communities, and then of course later on about mining. Where are the indigenous women? I would meet them early in the morning or in the evenings, chatting with them, asking them what they think about what we were discussing. Some would have a lot to say, others would be quiet, saying that they agree with their husbands or their fathers. The question of where the indigenous women are went beyond me and became an institutional question. So LRC thought we would proactively seek out the voices of women. Then we would request to also have women present and participate in the meetings, trainings, discussions that we would organize. We said that in strengthening the communities, we would also like to contribute in the empowerment of other members of the communities, that is the women. At first, it was very awkward. Either the leaders and the local organizations would forget or not take the request seriously. The attendance in the meetings would still be like 85 to 90% men. Later on, there would be some women attending who would turn out to be wives of the datus. But later on, more women will be attending, but they would not be speaking or participating. One of the events that we organized at LRC was the SIPA, or the State of Indigenous Peoples Address. SIPA started in 2008, and the main objective was to have a parallel SONA, or State of the Nation address, as Indigenous peoples' issues have always been absent, if not misrepresented. In the third SIPA in 2011, we decided to have a pre-SIPA gathering for Indigenous women. We held this in Coronadal and was attended by around 40 Indigenous women from Luzon, Visayas, and Mindanao. For 2 days, we heard women's voices on the issue of land, deforestation, militarization. But we also heard their stories about discrimination on a daily basis, malnutrition of their children and other health issues brought about by the deforestation, stories of how they are losing their indigenous ways of healing as they lose their forest, the lack of education for their children and how this keeps them from progress. We heard about stories of domestic violence, stories of their own difficulties as food gatherers as land grabbing persisted. We heard the indigenous women and we saw them too. As they joined the bigger group for the SIPA, they were very active, as if we're coming together as women and hearing each other's voices boosted their confidence. Nanay Remedios, an elderly from Ati Bukidnon community, stood up and told the men and women of SIPA, let's go to Malacanang and demand that they speak to us to know our real situation. After that gathering of Indigenous women, the women who participated came to us and said, we need that space. We need that kind of space that we can think on our own as women together and talk so that we can join the other meetings with better understanding of our situation and perhaps actual contribution to the discussions. Thus, the beginning of LILAC Purple Action for Indigenous Women's Rights. When I and then Ismael left LRC after so many years, and upon the prodding of Indigenous women leaders we worked with, we organized in 2012 the first National Indigenous Women Gathering. It was held in Quezon City with 40 Indigenous women, again from Luzon, Visayas, and Mindanao. And this time we went to Malacanang thereafter, bringing with them the issues of discrimination, violence, land grabbing, government neglect, and the commitment that they will keep organizing, learning, and taking actions in their communities and outside. So my first reflection, there is a need to create spaces, safe spaces for Indigenous women, that they can think and reflect on their own experiences and learn new things and information. It's always difficult to think as an individual, but more so as a woman. There always have to be a prodding. Think, imagine, and dream as a woman. In fact, one Aita told us, pwede pala yun. Kasi laging bilang nanay, bilang bahagi ng isang malaking komunidad, ang kanilang pag-imagine ng kanilang sarili. These spaces also build confidence, and that is crucial for them to be able to speak and to act. For someone who has not been asked of their opinion beyond childcare or domestic work, or who have not had the opportunity to speak to other people beyond their community. So LILAC has pursued its convening of National Indigenous Women Gathering as well as regional gatherings. This year we held it online, of course, participated in by more than 100 women coming from 15 different Indigenous communities throughout the country. In each of the gatherings that are convened, Indigenous Women Agenda is developed and an Indigenous Women Steering Committee is formed who would plan and act on the agenda. They would have dialogues with relevant national agencies such as TNR, DSWD, NCIP, at least before, and CHR. Members also of the Senate and Congress would meet with them. LILAC conducts community learning sessions on human rights, women human rights, IP rights, and other critical issues such as mining, logging, and extractive industries in the context of corporate-led development, climate change, among others. These experiences, though still limited, have contributed to new knowledge building as well as skills learning for Indigenous women. These, along with the sisterhood that has developed among them, have built confidence among themselves. Part of the spaces that are being carved out are the representation in different social movements, formations, and campaigns, even in national women's groups and formations. In IP representations and meetings, while sometimes we still need to remind the male leaders to extend the invitation to women in their communities, most of the time it is the Indigenous women themselves who claim their space in the representation. Also, as the communities recognize their leadership, the women are slowly given their own spaces within the Indigenous peoples' organizations, and in some areas, even within the Indigenous political structure. Such is the case with the Timoy Justice and Governance of the Tediray and Lambangian peoples. For the Igaonon Indigenous people political structure, they have now women leaders as part of their structure. Bae Rose Undag, Vice Chair of the Board of LILAC, and has been appointed as one of the Babayon, or woman member of the council. Their IPS or Lipendagan used to be male-dominated, but with their assertion, their leadership has been recognized by the Igaonon communities, especially within their ancestral domains covering Claveria, Dinoog, at Malitbong, in Misamis Oriental, and in Bukidnon. I am in no way attributing these developments to the work of LILAC. I'm just giving examples where, because of the assertion of the Indigenous women themselves, not without struggle though, they are able to occupy spaces of leadership within their own Indigenous political structure. This leads me to reflection number 2. Indigenous women's rights are something that has to be advocated within Indigenous people's communities and families, as well as within the broader women's movements. to participate and be present in these spaces within the IP organizations and formations, as well as within the broader women's movements, is a good thing. But to be able to influence these broader groups and formations to take on the issues of Indigenous women is yet another struggle. Let me talk about the Indigenous people's advocacies. FPIC, or Free Prior Informed Consent. This has been a collective call of Indigenous peoples, the implementation of genuine process of FPIC. However, NCIP guidelines point to traditional leaders as the main party of this process. When Indigenous women raise their lack of participation in this process, the NCIP and the corporation themselves say that is not our concern. We respect the traditional leadership. So this is one of the advocacies of the Indigenous Women Steering Committee, that a genuine process of FPIC is an inclusive one, recognizing the role of Indigenous women. Thus, in 2016, the NCIP, under the leadership of then Commissioner Leonora Quintayo, an en-banc resolution was passed, recognizing the contribution and leadership of Indigenous women in their communities. Of course, that was a pre-Duterte composed NCIP. There is also the IPMR, or the Indigenous People Mandatory Representation. The collective call of IPs is the implementation of this representation according to the customary practices of the communities. However, most of the customary practices are not encouraging for Indigenous women to participate. In the 2015 data of NCIP, there were only 467 women out of 2,782 IPMRs, or 17%. We moved to Bangsamoro Transition Authority, which governs the new Bangsamoro Autonomous Region in Muslim Mindanao, at least until 2022, although the election has been postponed, that means beyond 2022. It has 75 seats in the parliament. Out of the current composition, there are 12 women who have been appointed. None of them is a non-Moro Indigenous woman. There is a one seat reserved for non-Moro Indigenous peoples, and of course, that has been given to a male Teduray leader. While there is a growing recognition of Indigenous women's leadership and roles in the community, it is still a struggle for them to be part of the official decision-making structures. And going to the broader women's movements, there's also the need to highlight the different contexts and realities of Indigenous women. Women, after all, are not homogeneous, as we know. On the sexual and reproductive health and rights, for example, this is a common advocacy of women activists. The Sustainable Development Goal target: ensure healthy lives and promote well-being for all at all ages. By 2030, the target is to reduce the global maternal mortality ratio to less than 70 per 100,000 live births. In response to this target, local government units have issued no home birth ordinances. The women's advocacy then is for the government to ensure that women have more access to and capacity for facility-based deliveries. However, Indigenous women find the no home birth policy discriminatory against them. The Indigenous women have very strong practices and beliefs on home births, either preferably alone, as in the case of Alangan Mangyan and Blaan women, or with the Indigenous birth attendants, or paltera as they are called. The actual birthing is just part of the care that the Indigenous birth attendants give to the mother. She is being cared for during the pregnancy stage, birthing, and the healing part thereafter, and the care for the newborn. This is the whole package of care, using traditional methods and herbs from their land and forest. Moreover, even if they would opt to give birth at government facilities, this would be very costly for them. The transportation alone that would take them out of their village would cost a lot. As an example, in Compostela Valley, Mandaya women have to walk 75 kilometers, or almost a day walk, to go to the birthing center. That's how far it was. Even if they take a habal-habal at some point, that would cost them so much. So this means also they do not know exactly the time that they would give birth. This means that they have to stay in the town until the time of their birthing. This means that they would have to spend for food and and stay in their pay for their stay in their town, not just for themselves, but for their husbands and perhaps children who would go with them. So the indigenous women have practically no choice, given the circumstances, but to give birth in their homes. The state should be supporting the health of indigenous mothers and newborns by recognizing the indigenous knowledge, systems, and practices of women, providing accessible facility-based birthing facilities, which are within or closer to their communities, and integrating the indigenous knowledge and practices of home birth into the medical practice, thus making the birthing experience more culturally appropriate for the mother and the newborn and the entire community. Instead, the government chooses to criminalize indigenous women and the palteras for their beliefs and practices. For this reflection overall, their issues have to be integrated, and for that, more intense networking and movement building has to be done by the indigenous women within the indigenous peoples organization and the broader women's movements. Let me move very quickly to reflection number 3. Patriarchy in our societies has rendered indigenous women more vulnerable to multiple layers of violence and discrimination. As part of the communities which have been targets of corporate-led development such as mining, dams, and plantations, indigenous women suffer the violence of displacement, hunger, and increased poverty. However, sexual violence has been a consequence, if not a component, of these corporate-led violence. In the recent case of the Teduray and Lambangian communities in Barm, which have been violently displaced by armed Moro groups to grab their lands, the Inged Pintaylan, or the Indigenous Women Group, has documented rape cases even within the evacuation centers. Now, in the time of pandemic and lockdown, acts of violence against women have increased. Our partners in Bukidnon, among the Kirintaken, Erumanen, Manovo, they tell us of the increased number of rape and incest. Teenage pregnancy is on the rise, as well as girl-child marriages. As indigenous women have become actively involved in their community issues, there is also an increase in the number of indigenous women human rights defenders. Young indigenous women are also organizing themselves, and they are actively participating in learning sessions and community actions. Now, that's the good news. As they participate more in protest actions, mobilizing efforts, and in broad campaigns. However, this active presence has also posed challenges in their lives, primarily because they are women. In their families and communities, they receive criticisms ranging from neglect of their duties as wives, as mothers, to being promiscuous. Sinasabi, ba't kayo alis na alis? Kung saan kayo pumupunta, siguro may kinikita ka. May kinikita kang mga kalalakihan o kalaguyo. Sometimes these accusations actually result to domestic violence, and as they become more vocal and effective in organizing indigenous protests and actions, the indigenous women become targets of threats and acts of violence from corporations and the state itself. Under the Duterte government, women are under attack. Indigenous peoples are under attack. In the past years, Philippines has been in the top list of having the most number of community and IP leaders killed. These killings are in the context of defending their ancestral domains. But most of the violence against indigenous women happen in the shadows or in far-flung areas. This isolation limits the reporting, thus the culture of impunity is perpetuated. Reflection number 4, and I'm going near the end. The struggle for self-determination of indigenous peoples should have as an integral component the self-determination of women. Women's issues, particularly gendered violence, are somehow seen as secondary to the overall right to self-determination struggle of indigenous peoples. For self-determination to be truly meaningful and liberative, indigenous women's right to self-determination should be recognized and made integral to the overall struggle of the indigenous peoples. My 5th reflection is that there is a need even among the indigenous women themselves and among us, a recognition of the intersectionality of our identities and our struggles. In this year's National Indigenous Women Gathering, the focus has been on looking deeper into the different identities of women, of indigenous women, as farmers, as migrant workers, as senior citizens, as youth, as indigenous women with disabilities, as members of the informal sector, and as indigenous women human rights defenders. This allowed us to look closely into the particularities of the issues that they experience, but also celebrate the intersections with the other members of the basic sectors. This year's gathering emphasized the intense need for solidarity across and within communities, among women, and the basic sectors. And lastly, reflection number six. There is a need for more dialogue and discourse on Indigenous women's rights, the struggle for self-determination as a collective of women and as peoples. There is very little opportunity for me to reflect. The same is true with LILAC as a collective of women human rights activists and feminists and Indigenous women. Spaces like these are very important. So I thank you for the invitation. And I look forward to learning from Ms. DAYTEC, from Jeffrey Laura, and Ms. Jennifer Joseph. Maraming salamat po.
Thank you so much, Ma'am Judy. No, I really love how na-insert no po yung perspective ng IP women through all the issues of indigenous peoples that we have been discussing for these 3 days of lecture series. So maraming salamat po, Ma'am Judy, and we will hear more from you later in the open forum. So now supposedly our first speaker kanina, no, pero ngayon lang po siya nakapasok. Sends her apologies dahil po ata sa security settings because she is joining us from Geneva. Yan, ayun. So our next speaker now will be discussing gender and the Indigenous Peoples' Rights Act. Attorney CHERYL DAYTEC-YANGOT is the head of the Philippine Overseas Labor Office in Geneva, Switzerland. She's currently the labor expert representing the Philippines in the International Labor Organization, where she has built a reputation for speaking for IPs and migrant workers. Prior to joining the Department of Labor and Employment, she was an Assistant Secretary of Justice in the DOJ and was responsible for setting up an IP desk which she also headed. She has more than a decade of teaching law and other law-allied courses and was active as human rights lawyer and indigenous rights activist. Before moving to Geneva, she was a lecturer of the mandatory continuing legal education program of the UP Law Center on indigenous peoples, women and gender issues, and the environment. She has published works about IPs in international law journals and is a speaker in various fora on IPs, human rights, and gender. Akangkanay Igorot, born in Baguio, who traces her roots to Basao Mountain Province. She is a poet, wife, and mother to 3 children whose names reflect their indigenous identity, Denay, Lugat, and Gawani. So please welcome Attorney CHERYL DAYTEC-YANGOT. Attorney Chit, pwede na po kayo mag-share screen or unmute.
Hi, good afternoon to all of you. It's actually morning in Geneva, but outside it's still very dark. And before anything else, I'd like to thank UP Baguio for this invitation. In particular, I'm grateful to Dean Leah Abayao for extending this invitation, and to all of you, because this is something that I really love to do. We really should always talk about gender and indigenous people. So my lecture will be somewhat legal. I'm so glad that the first speaker, Ms. PASIMIO, spoke on intersectionality of discrimination. So I will not really touch on that, although it was supposed to be part of my lecture, but I'm glad she did talk about that. So let's first begin. When I was listening to Ms. PASIMIO, I really wondered whether gender-based discrimination is embedded in our culture. And then I remembered this film, Walang Rape sa Bontoc. It's a multi-awarded documentary, and its main source was Professor June Brett, the great one from UP Baguio. I had a cameo appearance there, siguro mga 3 minutes or 2 minutes or 30 seconds. Essentially though, ang sinasabi ng walang rape sa Bontoc, maraming violence, forms of violence against women na sa tingin natin ngayon ay parang embedded nga sa culture. Actually though, this might not be the case. Why? Because there was a time when really there was no rape in Bontoc, but subsequent evolution of the culture resulted in rape becoming no longer a phenomenon, but an occurrence, although not regular, but it does occur, and violence does occur. But we will get into that later on. For now, let me walk you through the provisions of the IPRA, or the Indigenous Peoples' Rights Act, on gender. So it's not a fact, or rather it's a fact that the IPRA does contain provisions on gender. Let me call your attention to section 2 on the Declaration of State Policies. It says, the state shall recognize and promote all the rights of indigenous cultural communities enumerated within the framework of the Constitution, and shall guarantee that members of indigenous cultural communities, regardless of sex, shall equally enjoy the full measure of human rights and freedoms without distinction or discrimination. Now, there's another one, and it says in section 26, women shall enjoy equal rights and opportunities with men as regards the social, economic, political, and cultural spheres of life. The participation of indigenous women in the making process in all levels, take note, all levels, as well as in the development of society, shall be given due respect and recognition. And then in section 40, when the IPRA talks about the composition of the National Commission on Indigenous Peoples, it says that at least 2 women of the 7 commissioners should be women. So out of 7, 2 should be women. Now, also in section 26, it talks about women having the right to full access to services, including maternal and child care. So yes, the IPRA is not silent on gender. It does have provisions that protect women, that promote their rights. But although this is a talk on gender and indigenous peoples, allow me also to walk you through how embedded discrimination is in the legal system. And this is the same legal system that gave birth to the Indigenous Peoples' Rights Act. And it is the same system that gave birth to the very structure, state structure, that interprets the application of the Indigenous Peoples' Rights Act. So there are indeed legal challenges in addressing gender-based issues, especially as they affect indigenous peoples. But well, we know that indigenous peoples are the same as the rest of the Filipinos, but at the same time, they're not the same. The Philippines is a country that is very diverse, and indigenous peoples are diverse, different from the rest of the majority population, and even among themselves, they're not homogeneous. They are also diverse. Now, if we look at how states have responded to diversity, to cultural diversity, to ethnic diversity, to whatever diversity, the responses have ranged from repression to accommodation. Repression would take the form of wars. In some parts of the world, wars have been committed against ethnic minorities in order to promote quote and unquote peace. And peace meant that these ethnic minorities would have to be among the majority. They would have to be part of the majority. Now, in the Philippines, how did the state apparatus deal with indigenous peoples? When the Americans, we know that before we go to the American period, let's first look at the indigenous peoples during the Spanish times. Now, what did William Henry Scott say? He said that he found it really strange that textbooks in Philippine history never mentioned the fact that for more than 300 years, the indigenous peoples, particularly the Igorots of northern Luzon, have been fighting for their self-determination. And unlike their lowland counterparts, they were able to resist colonization. So that was what happened during the Spanish times. But when the Americans came, the treatment was different, or our fate took a different turn. So President McKinley gave an instruction to the Philippine Commission, which was then the equivalent of Congress in 1900s. And what did he say? He said, in dealing with the uncivilized tribes of the Philippine Islands, the Commission should adopt the same course followed by Congress in permitting the tribes of our North American Indians to maintain their tribal organization and government, and under which many of those tribes are now living in peace and contentment, surrounded by civilization to which they are unable or unwilling to conform. See? You can hear the very ethnocentric, very racist tones here. He further said, such tribal government should, however, be subjected to wise and firm regulation. And without undue or petty interference, constant and active effort should be exercised to prevent barbarous practices and introduce civilized customs. So this is the American president speaking. I was talking about, manifest destiny and the white man's burden. And at this point, I should tell you an anecdote. Before the United States invaded Iraq, I remember the I think information minister of Iraq, who made an appeal to the world not to support George Bush, and he said that it's very unfair for the U.S. to claim that it should invade Iraq to civilize the Iraqis. Let me remind George Bush that when the ancestors of Saddam Hussein were building roads and hanging gardens, the ancestors of George Bush were in Europe wandering in caves, and they were naked. So that's what the minister then said. So it's really very it makes us angry really when people or when countries of power arrogate unto themselves the seeming God-given right and claim to civilize the rest of the world. So by saying that he wanted the action of the US as regards the American Indians to be the same treatment to be applied to the indigenous peoples of the Philippines, McKinley was actually talking about assimilation. And we know that in the United States, the US government had assimilation projects directed at the American Indians. And these projects were standing on the motto or on the command, kill the Indian and save the man, which meant you had to take away everything in the Indians that made them American Indians. They had to become like the rest of the white Americans. So that's what's been happening. Now, what happened in the Philippines? Supreme Court decisions are living testimonies to how the Philippine government dealt with indigenous peoples in this country. In 1919, the Supreme Court decided the case of Ruby versus Provincial Board of Mindoro. So Mr. Ruby was a Mangyan. And at that time, the Mangyans were given a portion of their ancestral domain within which to roam, within which to live, within which to work. So they were segregated from the rest of the society at that time. Now, this was done by virtue of course, how else? What's the best substitute for brute force? The best substitute is the law. So instead of using violence, you use the law. So an ordinance was passed saying that the Mangyan should stay in a particular space in Mindoro. And this really angered Ruby and the rest of the Mangyans, so they went to court. Now, how did the Supreme Court of the Philippines decide that? It said, Mr. Ruby, why are you complaining? Don't you know that this segregation actually constitutes protection? So you can see how Orwellian the language is. The Supreme Court said further, the Mangyans are not free as civilized men are free, and they are not the equals of their more fortunate brothers. True indeed, they are citizens with many but not all the rights which citizenship implies. And true indeed, they are Filipinos, but just as surely, the Mangyans are citizens of a low degree of intelligence, and they are Filipinos who are a drag upon the progress of the state. That was your Supreme Court speaking in 1919, saying that the Mangyans were people of low intelligence and they were weighing down development. They were preventing development from happening in the country. Thankfully, there was one judge who dissented. There was one justice. The justices then were mostly white people. And this was Percy Moore. He said, the Mangyans are not a separate state. Legally, they're Filipinos. They are entitled to all the rights and privileges of any other citizen of the country. So they were not, their right to due process was not observed when they were segregated from the rest of the Filipinos. Now let's move forward to 20 years later. And this case happened in the Cordillera. So there was a man named Mr. Kayat. I don't know how he's related to the current commissioner of the National Commission on Indigenous Peoples, Gaspar Kayat. But Kayat was found in possession of A11 gene at the time. And this was in violation of Act numbers 1639, making it unlawful for a native of the Philippines to drink. If you were a native and you're a member of what then was called a non-Christian tribe, it was unlawful for you to drink anything with alcohol. And Mr. Kayat did drink alcohol. So he was sentenced by the Justice of the Peace Court of Baguio City to pay a fine of 5 pesos. If he was not able to pay the fine, he would have to suffer imprisonment. Now, Kayat felt that that was unfair. So he went to the Court of Appeals to question the ruling. And what happened was, sometimes you go somewhere hoping that you get better treatment. But in the Court of Appeals, his penalty was increased to 50 pesos. So it was 10 times higher than the original sentence given him by the Justice of the Peace. So he went to the Supreme Court. And what did the Supreme Court do? The Supreme Court said, no, Mr. Kayat, your rights have not been violated. But let me look at my notes. I'll read to you what were the exact words of our Supreme Court. It said, as these less civilized elements of the Filipino population are jealous of their rights in a democracy, any attempt to treat them with discrimination or to mark them as inferior or less capable or less entitled will be met with their instant challenge. And it went further to say that it becomes imperative to examine and resolve the issues raised in the light of the policy of the government towards the non-Christian tribes, adopted and consistently followed from the Spanish times to the present, more often with sacrifice and tribulation, but always with conscience and humanity. Again, very Orwellian. And then it said, throughout the Spanish regime, it had been regarded by the Spanish government as a sacred duty to conscience and humanity to civilize Mr. Kayat, less fortunate people living in the obscurity of their ignorance. Mr. Kayat should know that the law preventing him from drinking A11 gin was actually designed to promote peace and order in the non-Christian tribes so as to remove all obstacles to their moral and intellectual growth and eventually to hasten their equalization and unification with the rest of their Christian brothers. See? So I don't want to go to two more cases, but those two cases should be enough to tell you that discrimination has been ruled constitutional by the Philippine Supreme Court in the past. But they found out, or rather the Philippine government found out that assimilation, or they believe that assimilation seemed to be working. In fact, they put up many offices in order to assimilate indigenous peoples. They put up the tribes. They put up the CNI, Commission on National Integration. They put up the Philippine Authority on National Minorities. And yet, hindi pa rin nangyari yung gusto nilang mangyari because the indigenous peoples remain to be indigenous peoples. They were still asserting their self-determination. So, if you are the state trying to assimilate these people, but you don't succeed, what do? Some states have resorted to the other, they have moved to the other side, which calls for accommodation. Remember what I said earlier, that the response of states has ranged from repression to accommodation. And in the Philippines, we actually have a policy of accommodation now. We no longer have a PANAMIN. We no longer have a Commission on Non-Christian Tribes, but we have a National Commission on Indigenous Peoples. And by accepting the use of peoples, the government is now recognizing that indigenous peoples are peoples. Peoples, they have claim to self-determination. Now, assimilation, or rather accommodation, is a counter discourse to assimilation. What do you do when you accommodate? You favor, for example, you may try to favor members of a disadvantaged group, or a group that has suffered or continues to suffer from discrimination. How? By giving them preferential treatment, by giving them quota system, or by giving them differential treatment. I think preferential treatment is protectionist. Quota system may also be protectionist, but differential treatment is, for me, liberating or empowering. So we do have a recourse to affirmative actions in order to bridge inequalities and opportunities and increase access of the marginalized to whatever services there are. So in the Philippines, in the legal system, we accommodate what we call legal pluralism. So it is an affirmative system. Or rather action. So when we talk about legal pluralism as an affirmative action, what do we exactly do? We recognize that indigenous peoples have their own legal systems, and we have to respect that legal system. Now, why? Because, the positive law are the laws that are passed by our Congress, the Senate, and the House of Representatives are under-inclusive, and they fail to take into account that there are laws below, outside, and all around the state. Now, if you open your IPRA, your Indigenous Peoples' Rights Act, you'll find provisions there that will tell you that the Philippine government, through that law, has respected the right of indigenous peoples to apply their own customary justice systems. So there's a provision on the right to resolve conflicts in accordance with customary laws. There's another provision that says that IPs shall have the right to use their own commonly accepted justice systems, conflict resolution institutions, peace-building processes or mechanisms, and other customary laws and practices within their respective communities, as may be compatible with the national legal system. Okay, so it's still the national legal system that is superior, and indigenous justice system is allowed to thrive for as long as it does not conflict with the national legal system. Now, before we talk about Philippine cases, I'd like to introduce you to a case that happened in the United States in 1883, more than 100 years ago. And this is the case of ex parte Crow Dog. So there was a Lakota named Crow Dog. Lakota is one of those indigenous peoples in the US. Crow Dog, he shot and killed Spotted Tail, a tribal chief. Mayabang daw itong si Spotted Tail. Mas mayabang itong si ex parte Crow Dog. So nainis siya because Crow Dog and the rest of the community felt that Spotted Tail was compromising their interests. Now, after Crow Dog killed Spotted Tail, the tribal council settled the case according to their tradition. And so Crow Dog and his family paid the family of the dead chief. Now, the authorities of the United States prosecuted Crow Dog for murder in a federal court, and they convicted and sentenced him to death. And Mr. Crow Dog went to the Supreme Court where he challenged the sentence. And this was what the Supreme Court said, speaking through Justice Matthews. The American justice system tries Mr. Crow Dog not by his peers, nor by the customs of his people, nor the law of his land, but by superiors of a different race, according to the law of a social state of which he has no perfect conception, and which is opposed to the traditions of his history, to the habits of his people's lives, and to the strongest prejudices of his savage nature. One which measures the red man's revenge by the maxims of white man's morality. Very beautiful. And so Mr. Crow Dog was set free. And that was the recognition of legal pluralism. Now, why am I making a recourse to this? Because I'm bothered that recently there have been cases decided by our own Supreme Court, brought by tribal chieftains from down the south, where the cases involved rape. And in two cases recently decided in the last 5 years, the victims were minors. And the datos were claiming that the cases should be settled not by the courts of the Philippines, but by the tribal courts. And in both cases, the datos were presenting acquittal made by their respective tribal courts. Thankfully, the Supreme Court of the Philippines has said that we do not apply or we cannot apply your indigenous justice system where cases involve crimes, because crimes are offenses against the state. You can use your indigenous systems to settle cases that are not in the nature of crimes. Now, do I agree? I actually disagree. I disagree that criminal liability should not be a subject of compromise in an indigenous community. You know, we have to allow them to use their justice system to settle cases, even criminal cases, when the settlement is necessary for the continuation of their identity as peoples. If it is necessary to maintain community peace, we should allow them to settle. Because sometimes the alternative could lead to more damages to the community. For example, it can trigger a tribal it can trigger a tribal war or something not probably as bad as that, but something that's also not not good. In the South, for example, there is Rido. So, or tribal war. Even here, even in recent years, there have been cases of tribal wars. So I think in those cases, we should allow settlement or the application of the indigenous justice system to settle cases. But when it comes to rape, what is my, what do I say to that? I would like to say that I still believe in legal pluralism. And in the cases of rape, should we allow the indigenous system to decide on that? I give a qualified no. I give a qualified yes answer. Yes, we can settle rape cases, but the decision must be coming from the victim with full understanding of the consequences. It is not for us to tell a woman or an indigenous woman to prosecute a case, nor is it for us to say that she should not prosecute a case. We should not use our indigenous system to pressure her to have her case decided by the indigenous courts. But at the same time, we should not use pressure to force her to prosecute under the national legal system if that is against her will. If we respect the self-determination of indigenous peoples, we should also respect the self-determination or the self-agency of the woman. Finally, let me say that indeed there is intersectionality of the discrimination suffered by women, because now I hear that even if we've been saying walang rape sa Bontoc, pero cases, well, a study by the IBP sometime in the early 2010s said that young indigenous women are being forced to marry men 6 times their age in arranged marriages. Rape is also considered an ordinary case that is confined to the expertise of the tribal leaders and are being settled amicably. And worse, rape victims are forced to marry the perpetrator because in those cultures, rape is a form of marriage. And then there are now cases of incest. What happened to walang rape sa Bontoc? What happened to walang rape sa Bontoc? I think this is a very important subject that we should be studying later. But let me say that the intersectionality of discrimination may have led to this as well. Indigenous peoples are being displaced from their lands, so they suffer from economic challenges. And in the process, women also suffer. Without economic power, they become more vulnerable to violence. They become victims of trafficking. I work with the Philippine Overseas Labor Office, and it sometimes surprises me to find out that there are many indigenous women abroad, working abroad. So I'm thinking maybe the ancestral domain is no longer able to sustain their families economically. And in some cases, women, including indigenous ones, become victims of sex and other forms of human trafficking. So this is really sad, and this is something that we should address. And having this forum this morning is a positive step towards that direction. Thank you so much. I'll be very happy to listen to other speakers and to answer your questions later on, should one arise. Thank you.
Thank you, Attorney CHERYL. So, we have situated through that lecture gender in the IPRA, not just in the IPRA, but in the overall framework of the legal system, which has institutionalized discrimination against IPs for the longest time. No? So, again, we encourage the audience to send in their questions through the chat box or in the Facebook live stream. And our next speaker is bringing in another perspective on LGBTQ rights and indigenous communities. JEOFFREY is a queer development worker, writer, and activist. As a writer, he penned stories for regional grassroots media outfit Northern Dispatch. Presently, he serves as the Secretary General of Tongtongan Piumili, a network of progressive people's organizations in Baguio City, and the urban chapter of the Cordillera People's Alliance. Geoffrey?
Thank you for that introduction, Karin. Good afternoon to us all. I would like to start by expressing my thanks to the organizers of this lecture series, particularly UP Baguio's Kasariang Gender Office for the invitation to be part of this panel. I am deeply humbled to be in the company of many distinguished personalities. So thank you. Dako ay iyamang kanda kayo ay organizers. Isa na opportunity ay to speak on such important matters. And I would also like to thank the first two speakers, Ma'am Judy and Attorney Chit, for the very substantial sharings and for historicizing our quest for self-determination. And of course, I would like to greet everyone listening and participating this afternoon. I understand that we have participants from all over the country. So from all of us here in the Cordilleras, gawis ay masdem, kung ako amin, na imbag na malantayo amin, magandang hapon sa ating lahat. Sana itong discussion or this input could contribute towards our common goal, which is the full realization and respect of the rights of Indigenous peoples, the LGBT+, and the other marginalized sections of our society. So let me share my screen. So, can everybody see the presentation?
Yes, okay siya.
I was asked to share on LGBT+ rights and Indigenous communities. And while I will try my best to encompass the topic asked of me, I would like to zero in on the struggles of both sectors for the recognition and respect of their rights and identities. Particularly, I would like to focus on three things. First, the intersections of Indigenous and queer identities, the commonalities of their struggles for their rights and how it manifests in advocacy and activism. Second is the perspectives of Indigenous peoples or cultural communities, IPs, ICCs, on queer identities, specifically their narratives from traditional elders and the negative and positive aspects of these perceptions. And then third is how we can use these perspectives in working towards the recognition of both rights and identities of the LGBT+ and IPs. So to start, let us briefly define what are Indigenous peoples and LGBT+ communities. As we all know, Indigenous peoples are distinct social and cultural groups sharing collective ancestral ties to the domains where they live. And within Indigenous peoples are women, men, the disabled, the elderly, the young, and of course the LGBT+ people. Broad issues such as national oppression and climate issues affect all these identities. On the other hand, we have the LGBT+ communities, the acronym LGBT+ actually serving as an umbrella term to describe a person's sexual orientation or gender identity. And these are communities who historically, like IPs, have experienced oppression throughout their existence. Both identities suffer systemic prejudice in several areas of their lives. There are distinct manifestations. For the former, the IPs here in the country, it is through national oppression, which can be seen through oppressive land laws and non-recognition of their rights to ancestral lands and domains, socio-cultural and economic discrimination, non-recognition of Indigenous social-political systems, ISPS or IKSP as we call it, commercialization and vulgarization of their culture, and militarization and ethnocide. Meanwhile, for the latter, the LGBTs, it is through lack of anti-discrimination laws, non-recognition of their civil, family rights, and economic rights, disrespect of their preferred identities, violence, and other human rights violations based on sexual orientation. So now we can see the similarities of the predicaments of both sectors. Both are oppressed peoples. But let's go back to what comprise IPs, Indigenous peoples. IPs include women, men, the disabled, the elderly, the young, and LGBT+. The LGBT+ people who are already suffering another whole subset of repression. And, researchers in the United States posit that there is some sort of minority stress suffered by sexual and gender minorities. There in the US, this is coupled with racial and ethnic discrimination against people of color and Native Americans. So this becomes what they call multiple minority stress. The study done by Balsam et al. In 2011 and published at Cultural Diversity and Ethnic Minority Psychology purported that lesbian, gay, and bisexual individuals who are also racial ethnic minorities are multiply marginalized populations subject to microaggressions associated with both racism and heterosexism. So for sexual minorities like LGBTs who are also part of ethnic minority groups, there is some sort of double jeopardy for them. And their only offense is because they exist. And that is present here too in the Philippines. No, we have the stories of That's Ann, a manobo po lang yun from Bukidnon, who related that being a lumad is already difficult. And what more, being a tomboy lumad. And of course, other queer indigenous persons. Anyway, we'll delve more into the perspectives of IP communities on LGBTs as we move along. In advocating, asserting for equal rights, especially in the context of queer persons who are also indigenous, there is a difficult balancing act that takes place. In the indigenous movement, for the assertion to the right to self-determination, we often call for the celebration of traditional knowledge and cultural practices. And sometimes these knowledge and practices are inevitably imbued with machismo and often have cemented specific roles for men and women, effectively marginalizing those who do not fall neatly in these binary categories. And this is a difficult subject to tackle, especially among our elders who uphold the traditional elements of the indigenous social order. However, these conversations with elders are conversations that need to be done. And we must recognize that these conversations can be and will be painstakingly long and arduous. But on a positive note, at this point, we already have queer indigenous persons speaking out, advocating for equal rights. These are queer folks who say, justice for me is equal rights for gays and lesbians. I would like to go back to That's Ann, who carries with her still her identity as an indigenous lumad and as a queer person whenever she speaks in protest and continues to participate in the struggle against displacement from their ancestral land. I would like to quote her, yan ang paniniwala ko. Kahit anong sasabihin nila sa akin, ipaglalaban ko talaga ang sarili ko at hindi lang ang sarili ko. Lalo na sa lupang ninuno. Ang pagka-LGBT ko, ang pakikibaka ko po. Ang pagka-LGBT ko ay lumutang sa pakikibaka, pinaglaban ang lupang ninuno dahil nga ang lupang ninuno ay buhay ng mga luma. And not just only for lumans, but also for the Igurots and all other indigenous peoples here in the country and around the world. Now let us take a look in broad strokes, the perspectives or the narratives of indigenous communities themselves on LGBT plus peoples. For this particular section, I will be sharing some personal narratives, encounters, and findings from an ongoing study being done by researchers with the Cordillera Women's Education Action Resource Center, or CWORK, which is a non-government organization focused on gender-based empowerment of the Cordillera Indigenous peoples' pursuit for land, food, and rights. So allow me first to contextualize by saying that queer identities have already existed in Cordillera societies even before the emergence of the contemporary terminologies such as bakla, tomboy, lesbian, or gay. And this is evident in how different ethno-linguistic groups in the region have terms to describe those who are queer, although limited to mean girl-like and boy-like, like among the Kangkanais and the Bontocs, the binalaki, binabai, among the Tingyans, lakyon, bayon, baiyon, the Kalinga na fayon, naugugyan, and the Ifugao lalaki and binabayi. So as present as they were, negative perceptions persisted, and it can be said that these opinions towards LGBT plus peoples among Cordillera indigenous communities are influenced by 4 factors, and the following factors are: 1, religion; 2, indigenous values and beliefs; 3, male chauvinism; and 4, socioeconomic standing. First is religion, because it is the primary mover in how queer identities are perceived by indigenous communities. The Spanish and subsequent American colonization, accompanied by the Catholic and Protestant politicization it came along with, left profound and lasting influences on our society. Here in the Cordilleras, particularly in the Christianized or Anglicized communities of Benguet, Montañosa, Kalinga, and Ifugao, Christian values greatly influence their perceptions of sexuality and identities. And through this, the binary idea of gender was strongly enforced, that there is only man and woman, as preached by the Holy Bible through the personas of Eve and Adam. And through time, their discrimination or the discrimination continued and even intensified because of the conservative values introduced by Christianity. And then now second are indigenous values and beliefs. Ethno-linguistic groups in the Cordillera generally put a prime on their land and its preservation. For Cordillera societies, preservation is through passing on the custodianship of the land to the next generation, from ancestor to children, to the next generation, and so on. This notion of inheritance primarily influences the perception that LGBT plus folks among Igorots that they cannot pass on the inheritance if they are unable to conceive. Saan nga makaanak, mabaakan. And then there were people saying, sayang ti pagkababae data, handamat nga ag-anak. And so on. No? Related to this is male chauvinism. Since Cordillera societies are feudal, patriarchal in nature, men are generally regarded to be more in charge and capable in many aspects of life. And this is apparent in many practices and traditions where men are put in higher regard over women. And thus this translates into how people regard the binabai and the linalaki. For instance, among Iguros in Montañosa or in Mountain Province, people regard the linalaki tomboys higher since isudati napipigsa, nagagagat. They are more stronger and industrious and they exhibit male-like strength, which is much valued in Cordillera societies. And then we have socioeconomic standing, which also includes the educational attainment of people. It was observed that those who have higher economic and educational standing are more accepting of queer folks. Educational attainment factors in because those who have more contemporary and progressive knowledge on sexual orientation and gender identities are generally more accepting of their queer identities and vocal about their openness towards queerness or identity as queer people. These negative perceptions and the factors which led to it contribute mainly to the discrimination and prejudice that LGBT plus folks are continuously facing. However, there are also positive perspectives and narratives which warrant amplifying. For instance, we have those who say, imbag pa'y dagijay babakla, tanapingit da nga ag eskwela, kat ni, mayat pa'y ti trabaho, kat tumultulong da pa'y kadi, tadakkel kan kakabsat da. Which translates to the gays are a lot better than you because they work hard to finish their studies and now they are gainfully employed and a big help to their parents and siblings. So no, from here we can see that socioeconomic status concretely influence perceptions among LGBT+. And then there's another, despite being frowned upon by traditional elders and teased or bullied by society in general, there is still some form of recognition of the identities of queer folks and their capacity to participate in traditional and productive practices. Such is manifested by a narrative related by a Sagada Igorot woman who said that even if the gays are effeminate, they still go to work at the fields as a means to prove themselves and their capabilities in a patriarchal social order. This kind of appreciation can be observed in contemporary times when LGBT plus identities and narratives slowly penetrate an otherwise conservative society. And one remarkable narrative I would like to share is from a traditional elder, a leader of indigenous urban poor communities in Baguio who hailed from the Lik in Bontoc. He said, "Uray man babakla, unutomboy, basta saan nga nasulton ket mayat mutta." Even if the gays, even if they are gay or lesbian, as long as they are not insolent, it is good. Since being gay or lesbian is not a problem as long as they possess good attitudes and helps in the community. Another remarkable narrative is awan problema no saan nga straight ti may nga tao basta straight lang tati panagpanunot na. There is no problem if a person is not straight as long as their mind thinks straight. And in this case, straight nga panagpanunot means doing no harm towards your fellows and upholding the indigenous values of Hinayan, Lawa, and Paniyaw. And then there are also the more contemporary examples, such as that of Tyler Falancy, an Bontoc child who proudly wears the lufid and other indigenous garments intended for women during the Pasokay harvest ritual among the Bontocs. Falancy even dances the sagni with the woman as the men beat the gangsas. And this the child does despite presenting as male at birth, and they are not ridiculed for doing so. In fact, the community, the Omili, does not ostracize the kid, but rather encourages them to be who they are. So how do we move forward now towards a society that is cognizant of the rights of all? As I've mentioned before, the process and conversations to dismantle the discrimination embedded within our collective consciousness will be painstakingly long and arduous. But from the narratives that we have heard and seen, we are given hope by the openness of some of our elders and communities. We must break down solitudes. We must be inclusive and not be divisive. And by breaking down solitudes, we are dismantling the shackles of misinformation, miseducation, biases, and prejudices that led to the discrimination that we have seen. Breaking down solitudes also mean organizing, conscientization, and awareness raising among queer indigenous folks. And this must lead towards their participation in the wider struggle of the exploited masses as part of their assertion of identity and the respect of their rights. And it is also a challenge for us to check our understanding on our rights as indigenous peoples and the yearnings and quandaries of the sector subsumed within it, the LGBT plus in particular. In our quest for the right to self-determination, we must equally campaign for the recognition of the LGBT+. And while it is important to protect indigenous cultural practices, knowledge, and identity, it is equally necessary to highlight sectoral rights. For there cannot be full respect of indigenous peoples if it includes those who are similarly exploited and discriminated. Our timely forum this afternoon highlights the importance of the academic community's role in giving space for discourse on otherwise sensitive topics such as this in the context of our region. May such activities be sustained as we all persist in our work for equal rights, right to ancestral lands and resources, and the right to self-determination. Maraming salamat. Matagot-tagot ako.
Thank you so much, Jeffrey, for that perspective on LGBTQ and indigenous communities. It's really less heard about, no, but it's also an important topic, especially when we are talking about gender and indigenous people's rights. So we now move to our last speaker. Again, I would just like to invite the audience to send in your questions, comments. There's an ongoing discussion now as well in the chat box. And to our viewers over at Facebook, pwede din po kayong mag-join in the discussion. Yan. So our last presentation on vernacular self-representation in Filipino gender identities on the Bontoc, Minamagkit, Jennifer Curry-Joseph is a feminist researcher, academic, and activist doing pioneer work on gender and sexuality studies and indigenous studies in the Philippines. Her MA thesis, which was the first academic study on Filipino lesbians and tomboys, was a recipient of the Lourdes Lontoc Cruz Graduate Thesis Award conferred by the University of the Philippines Center for Women and Gender Studies. She earned her PhD in anthropology from the University of the Philippines, Diliman. Her dissertation, Bontoc and Northern Kankanaey Bakla and Tomboy Desires and Identities, Intimate Bodies, Spaces, Histories, and Memories, is another pioneering work on gender, sexuality, and LGBTQ studies. She was a founding member of Kasarian, the Gender Studies program of the University of the Philippines, Baguio, which was founded in 1992. She is currently a member of the Board of Trustees of the Philippine Population Association Incorporated, which is a national association of demographers and demography enthusiasts. She is currently the chairperson of the Department of Anthropology, Sociology, and Psychology, and the program coordinator of the PhD in Indigenous Studies program of UP Baguio. Prof. JJ?
Hi, can you see me? Can you hear me?
Yes po.
I did magandang hapon sa lahat ng attendees natin sa komperensyang ito. I did a video, or I recorded my presentation, but I would like to introduce my presentation before we play the video. My presentation is about the Bontoc Minamagkit. And in the presentation, I will explain what the Minamagkit is. And my presentation can be divided into two parts. The first part is about vernacularization. This is the framework and the approach I'm advocating for. And then the second part of the presentation is about my findings about the Bontoc Minamagkit. I tried to stick to the 20-minute limit, so I did not include many of the findings, but I will be very happy to answer all your questions after the presentation. Maraming salamat sa University of the Philippines, Baguio, at sa mga kasamahan kong presenters, and it's my pleasure and honor to be part of this panel. Salamat, Karen.
Thank you, ma'am.
Good afternoon. The title of my presentation this afternoon is Vernacular Representation in Filipino Gender Identities, the case of the Bontoc Minamagkit. First of all, I would like to thank those who made possible the research, which was the basis for this paper. My sincerest gratitude to the Bontoc Minamagkit, as well as to the tomboy and bakla of Mountain Province for welcoming me into their homes, trusting me, and sharing their stories and experiences with me. Thank you to the provincial, municipal, and barangay officials in my research sites in Mountain Province, Bontoc, Sagada, and Tadyan. Thank you to the IPRA for not making my research process difficult. And thank you to the Southeast Asia Research Journal of SOAS, University of London System. My research was also facilitated with the funding support from the Cordillera Study Center of UP Baguio, the Mercedes B. Concepcion Grant of the Philippine Population Association, the University of the Philippines Baguio and University of the Philippines System, the University of Amsterdam Chemical Youth Research Project. Special thanks to Anita Hardon and Michael Limtan. My gratitude also goes out to Professors Michael Limtan, Junpril Brett, and Maria Dulce Natividad, my panel members. And in Mountain Province, to Joby Lopez, Sabrina, Dalia, Dixie, Abet, Nori, Tikoy, Rainet, and Bing. The objectives of the research was to trace the emergence of the identity and subjectivities of the Bontoc Minamagkit against the backdrop of the Chico River Dam conflict. I also documented the processes and context that facilitated the interactions and relationships between the Minamagkit and the government soldiers deployed in Mountain Province and Sadanga. I'm advocating for a critical analysis of Western, or what can be considered transnational concepts, framework, and approaches in gender and sexuality studies. I'm also advocating to explore the adoption of vernacularizations in gender and sexuality studies. Vernacularization is an approach when Western concepts or transnational concepts are adapted to local institutions and meaning. It was originally deployed to explain 19th century process by which the national languages in Europe veered away from medieval transnational use of Latin and creating a new and more differentiated sense of nationhood in Europe. There are generally two forms of vernacularization. One is replication, and the other one is hybridity. Replication involves the process of importing institutions, and these institutions or approaches or concepts remain largely unchanged from its transnational prototype. Again, there's the question whether this is really possible. How can a transplanted program or discourse can be symbolically indigenized and remain fundamentally unchanged. Another type of vernacularization is hybridity. This is described as a more interactive form with symbols, ideologies, and organizational forms generated in one locality merging with those of other localities to produce new hybrid institutions. This means that transnational ideas and discourses are blended with the local norms and discourses. Another relevant concept to vernacularization is indigenization. So indigenization is described as a symbolic dimension of vernacularization. There's a shift in meanings, especially to the way new ideas are framed and presented in terms of the existing or local cultural norms, values, and practices. An example is when a women's development NGO in India deployed Shakti, or the feminine spiritual power, as a way for women to imagine their power to contest all forms of oppression. So the symbol of Shakti was used in developing programs for anti-violence against women or gender violence in some areas in India. So in indigenization, you interweave local practices and discourses with external or transnational to produce hybrid discourses and subjectivities. One very important aspect of vernacularization is the role of the translator or intermediaries. These can be the researchers, the academics, the development workers, the advocates, etc. So these translators or intermediaries translate and negotiate between local, regional, national, and transnational systems of meaning. Their role is very important because translating one set of cultural categories and meanings into another context can result in misinterpretation, misreading, or even affecting change in the local context, systems, and processes. So these intermediaries and translators, which are researchers and academics and development workers, have a very important role to play in vernacularization and in cultural translation. Okay. Bohannon, a famous anthropologist, said that categories should be understood in their own terms. Anthropologists are often engaged in cultural translation. They translate cultural worlds of the people they study into the cultural worlds of their readers, students, government agencies, development planners, international institutions, etc. Now, cultural translation is underpinned by power inequalities, and there is a need to be more reflexive. That's why social scientists and anthropologists are very self-reflexive and aware that they should factor in these inequalities. Even the language and analytical frames are replete with power inequalities. Now, cultural translation is often deployed in gender and sexuality studies. Unfortunately, there is what I consider as an uncritical adoption of labels, identities, and subjectivities that were developed in other contexts like North America, Europe, East Asia, or transnational contexts. And these identities and subjectivities are not necessarily appropriate label for the local context. So you create a false equivalence. For example, the Western concept of and subjectivity of gay is not comparable to the bakla, the Filipino bakla. Ang gay ay hindi, ang gay sa ibang konteksto, in the West, in North America, in Europe, and even in East Asia, is not the equivalent of the Filipino bakla and the Bontoc, Minamagkit. There is also the propensity to use acronyms, LGBTIQA++. This stands for lesbian, gay, bisexual, trans, intersex, queer, asexual. And the letters keep multiplying, or they keep adding to letters to the acronym. There is also the use of SOGSC. SOGSC stands for sexual orientation, gender identity and expression, and sex characteristics. Now, these acronyms and the identities that fall under these acronyms may not be so accurate or may not be so appropriate in the local or vernacular identities and labels. There is also a preoccupation with gender and sexuality taxonomy and looking for the local counterpart of European and North American or transnational labels and subjectivities. So you develop identities and subjectivities in the West, for example, and then you try to look for its counterpart in the local context. For example, they have coined the term pansexual, demisexual, and then they try to look for its counterpart in the Philippines or in other Asian or non-Western contexts. There is also the propensity and insistence on imposing transnational gender and sexual identity categories on locals from different contexts. For example, I have encountered some feminists who insist that the Filipino tomboys should use the label transgender or trans man, and for all bakla to appropriate the label transgender or trans woman, in the belief that the tomboy and bakla just do not know any better, as they probably have not encountered the correct labels of transgender or trans woman or trans man. That is an assertion of a few feminists I've encountered in the Philippines. Now, I believe that the Bontoc Minamagkit is a form of vernacular representation and a valid local indigenous label and identity. The Minamagkit, the word Minamagkit comes from the Bontoc word magmagkit, and linguist Seydenadel in 1909 said that mamagkid or magmagkit means a young lady or maiden. He goes on to say that the infix in Minamagkit means imitation and or image. In this case, imitation or image of a woman. Minamagkit, therefore, as coined by the young bakla, for lack of a better label, coined and appropriated Minamagkit to mean like a young lady. They are not female, they are not young ladies, but they desire to be female and they want to be young, to be described as young ladies. Okay, the Minamagkit came of age in the late 1970s until the mid-1990s against the backdrop of the Chico River Dam conflict. They were aged 17 to their early 20s during the height of the Chico River Dam conflict and the ensuing militarization in Mountain Province and Kalinga. So during these times, the young boys experienced their sexual debut and explored their same-sex identities and sexual practices with the soldiers deployed in the region. Okay, the photo on the right is a Google photo of the military camp in Tabrak near Annabel in Sadanga. This is the approximate location of the military camp. So you have Bontoc Centro in your lower left corner, with the light blue marker, and then on your upper right hand corner is with the yellow circle is Tabrak, which is the approximate location of the military camp back then. Now, the military camp in Tabrak is where the Minamagkit were invited by the soldiers to parties and other special occasions. The military camp was also a venue for sexual encounters between the soldiers and the Minamagkit. This is a view of the rice terraces in Barangay Annabel in Sadanga, Mountain Province, where this is the everyday view of the soldiers stationed in the military camp. Now, this is in Bontoc Centro. This is the Bontoc Provincial Plaza. I took this photo in 2019. A few months before the pandemic. This is how it looks now, but this is the site where the sexual encounters happened in the 1980s and the 1990s between the Minamagkit and the soldiers. So the soldiers usually went on furlough in Bontoc Centro during weekends to drink in bars and the folk houses, in folk houses, and try to relax and break the monotony of their life in the military camp and military posts. So the young Minamagkit waited in the town plaza for the drunk soldiers to come out from the bars, and the young Minamagkit performed oral sex on the drunk soldiers. This is how the plaza looked in August 2021. They painted the stones in rainbow motif. This was during the 51st founding anniversary and 14th Lang Ay Festival in August 2021. So aside from the casual sexual encounters, there were several boyfriend-girlfriend relationships between the soldiers and the Minamagkit. The soldiers and some officers courted the Minamagkit and eventually lived together as husband and wife. Aside from the sex, the soldiers and Minamagkit provided friendship and companionship to each other. What are the reasons for the Minamagkit and soldier relationships? For the Minamagkit, they explored their gender and sexual identities and their sexual practices. The encounters provided sexual gratification and companionship and friendship. What were the contexts that served as impetus to the Minamagkit soldier sexual encounters? In Bontoc, there were cultural norms and practices that discouraged social interaction and intimate relations between the local women and the soldiers. So that's not allowed. There was also the absence of red light district or organized prostitution in the community. There was also the stigma on women, both local or transient population, who engaged in prostitution or casual sex with the soldiers. There was also no available venue for illicit sex. They cannot check in the few hostels because they will not be accepted, and they cannot have sex outdoors. The Bontoc Minamagkit also has this preference for secret sexual encounters with outsiders, not with the locals. They prefer outsiders or transient population. Now, these are the points to ponder. Had the Minamagkit not been there to provide sexual gratification, companionship, friendship, etc., how could the soldiers have dealt with loneliness, homesickness, and the need for sexual gratification? We all know that often where there are big military deployment prostitution and rape usually follow. Could the presence of the Minamagkit profoundly affected the dynamics of the encounters and interactions between the military and the people of Bontoc? What if the Minamagkit were not there to provide the emotional and sexual needs of the soldiers? What are the possible scenarios? Conclusion. Minamagkit is an example of local gender and sexual identity rooted in the vernacular and specific socio-economic cultural context. We need to unpack Western or transnational identities like the LGBTIQ++ concepts and paradigms and evaluate them in terms of relevance and appropriateness in local context and experiences. We need not go far and focus on the transnational LGBTIQA+ identities when we still have not adequately studied the Minamagkit or Schlegel's Teduray Mentefulaway Libun, or the man who became woman, and the Mentefulaway Lagay, or the woman who became man, and other non-heteronormative gender and sexual identities in the Philippines. Maraming salamat.
Thank you so much, Prof. JJ, for that. Very interesting on the story of the Bontoc Minamagkit as a truly local manifestation of a gender identity that does not necessarily fit in to the transnational Western labels that we are somehow more accustomed to, even more than the indigenous concepts of gender, such as the Minamagkit. So at this point, we now open our question and answer forum. I'd like to ask our speakers to get ready. Thank you to my co-moderators. We have been collating and all the questions and comments from the chat box. So medyo mahahaban po ng mga to, no? So I would like to sort of summarize so far what the discussions in the chat box have been touching on. So we see here actually the tensions of gender and IP rights more generally, and the gender and the IPRA more specifically. So we have here those tensions between state law versus customary law, and on another level of women and LGBTQ within customary law and within state law and within a patriarchal society that is more often than not in turn reinforced by the legal system. So napakahirap nga po to navigate and to examine how these identities and how these communities can advocate for themselves within this sort of system. And the commenters have brought up issues, for example, of rape, the dynamism of customary laws and legal plurality, human rights violations, individual and collective rights, and even gender and development. So perhaps we can start po with a sort of round table check-in ulit po sa ating mga speakers. What are your thoughts on that po? How can we navigate this tension between IP communities and the general national law and the gender aspect as well, no? IP women and LGBTQ communities from your own experiences po? Anyone would like to start? Perhaps we can start po with Attorney CHERYL to address some of the discussion that has been going on in the chat box regarding the issue of rape po and indigenous communities according to your discussion on gender and the IPRA. And nandito pa po ba si Attorney CHERYL?
Kung wala pa si Attorney CHERYL, can I
Sige
share?
po, ma'am. Yes, ma'am Judy, go ahead.
Ay, sige, kahit wala na lang video. Bawal daw eh. Yeah. I was just wondering, reading through the conversation sa chat box, hindi lang ako makasingit kasi I was listening intently kay Prof. JJ. But Yung experience namin, for example, sa Teduray, where I was discussing, we were talking about women's rights and different customary laws na. And then we of course went to rape. And then our stand has always been where the women or the woman survivor feels that there is sense of justice for her. So is she going to go to the court, or is she going to the traditional or customary law? Nung inuusap namin yon within the Teduray and Lambangian community, sabi nung mga babae, ay sabi nung mga lalaki pa yung medyo maingay. At ang sabi nila, bakit pupunta pa sa barangay? Edi mas expose pa yung kahihiyan na dinaranas ng survivor, ng rape victims. Sumagot yung ibang kababaihan. Ang sagot ay, kasi pagka-customary law, lagi lang ay either ipapakasal, and I think this has been mentioned, ipapakasal, o kaya magbabayad lang ng either hayop o at pera. So yung iba talaga would rather go to the national official legal system or the barangay muna nga. So sabi ng lalaki, may tumayo ding lalaki, and sabi niya, pag doon kayo pumunta, sigurado mapaparusahan kaming mga lalaki. So dapat dito lang sa customary law. So napaisip lang ako doon sa conversation na yun. It really shows, not really, but parang ang dating nung conversation, sila na lang yung nag-uusap, nakikinig na lang kami, na ang tingin talaga nung ilang mga kababaihan, they would rather go to the official legal system. Of course, meron ding ang laki rin ng setback, and I'm sure Attorney DAYTEC would share with us how women are being raped all over again kapag ikaw ay dinala sa official legal courts. Pero so in the end, ang sinasabi nga sana kung saan mayroong sense of justice yung individual, yung rape survivor. Nabasa ko lang doon sa sinabi rin ni Attorney DAYTEC doon sa chat na paano yan kung yung individual, may tension between the individual rights and the collective rights. Sabi nung isang Teduray woman na tumayo, at saka sinang-ayunan ng isang elderly din, hindi mangyayari yan yung tension na yan because we have kefyofe daw. Sabi ko, ano po yun? Yun yung peace of mind and heart ng community. So kung ang isa ay pakiramdam niya ay hindi niya nakuha ang sense of justice dahil dun sa naging resulta ng customary law, then we will not achieve kefyofe daw. So itutuloy natin yan kung saan magkakaroon ng peace of mind ang tanan, ang lahat. So tingin ko baka minsan gusto kong I would like to refuse to acknowledge that there is tension between individual and collective rights. We have to assert that always the individual rights are very integral to the collective rights of the communities. Yun lang po muna. I'm so excited to hear from Attorney DAYTEC and Professor JJ.
Okay, sige. Thank you po, Ma'am Judy. So perhaps we can have Attorney CHERYL and then Prof. JJ.
Thank you. I wanted to speak earlier, but I couldn't find my mic. Anyway, to me, the objective of every justice system should be restoration. It should be restorative, it should be healing, it should be fixing broken hearts and broken relationships. So what happens now if we have here a rape victim, a woman who decides not to prosecute a case, but there is community pressure for her to proceed because the community feels that that is going to promote communal or collective peace as well. It's a very difficult question, but I have to say that under the current national legal setup, actually, even when a woman even when a woman decides not to prosecute a rape, the 1997 rape law says that her consent to prosecute is not necessary. So at the same time, we have to look at what will give her peace of mind and what the law says and what the community says. So tatlo yan na nagkokontra. If I was to be asked to advise the woman on this or the community on this, I'd say this. As long as the woman gives an informed and voluntary decision, I will respect that. She is the ultimate victim. We know that every time a crime is committed, the entire community suffers. But there is one person there, 1, 2, 3 persons who are the direct victims who will suffer the most. Now, why should we foist upon her a decision to prosecute a rape case which she does not want to prosecute? So let her, as long as it's her decision, let her not file a rape case. Now, should the community file a rape case? I look at this from a practical viewpoint. It's up to the community. The legal or the law, the rape law allows them to prosecute a rape even if the woman says no. But there is a practical consideration here. How do you prosecute a rape case successfully without the testimony of the victim? So yan ang kailangang tingnan natin. Now, I'll go back to restorative justice. When we say that in particular cases, if the penalties are higher, we should go to the courts established under the national law. We are, that to me is discriminatory. Feeling ko hindi rin tama yun na pagtingin, because what we are saying is that customary justice systems are inferior to the national justice system in delivering justice. Sa tingin ko hindi. In my study of indigenous justice systems in various parts of the world, iba ang objective kasi ng indigenous justice system. Yun nga, restorative, healing, okay? Everybody happy. Ang objective ng ating national justice system, it's punitive siya. Revenge, no? Revenge. Ilalagay mo si Jose sa bilangguan kasi ito ang ginawa niya sa komunidad. And it is not necessarily true that the victims in that case that was prosecuted successfully under the national legal system are happy. Hindi ibig sabihin na porke si Juan ay na-convict sa pag-murder niya sa tatay ng mga nina A, ay natutuwa na sina A na there has been restoration of broken hearts. So, yan ang kailangang tingnan natin. Sa tingin ko, walang iisang dekahon na sagot dito, pero there are various considerations. And in cases of rape, I will defer to the decision of the victim for as long as her decision is informed and voluntary. And again, I would like to say na pag sinabi nating informed, naiintindihan niya ang consequences. So may tanong din kanina sa chat, dito ko na rin sagutin. Paano kung yung bata na nagsabing huwag i-prosecute ang rape ay menor de edad naman? Again, I will go back to the use of the word voluntary. I will go back to using informed. Am I saying that a child has no self-agency? Meron. If I say no, wala, we are actually going against the human rights of the child. A child has the capacity to decide. Considering, however, the minority and considering na a child does not have full information that we adults have, she has to be assisted by older persons and by the state. So no, I don't believe that when a child says no, let us not prosecute the rape case, and she makes that decision alone, I will not consider that a just, uninformed and voluntary decision. Thank you.
Thank you, Attorney. And Prof. JJ, I believe you were raising your hand a while ago.
Yeah. I would like to underscore, I think, 3 concepts here or 3 ideas. One, I would like to support the idea or the advocacy for integrating intersectionality. Kasi that concept is very important. We are not just IPs, we are not just women. There are so many dimensions to our beingness. So IP ka, Kankanaey ka, Ilocano ka, Anglican ka, may disability ka, Filipino ka, educated ka, etc. So gusto kong tingnan yon na yung IP lumad at yung individual existing in a specific context or in many contexts. So lalo na siguro yung hindi pa natin pinag-usapan yung Muslim, 'di ba? Yung merong talagang banggaan halimbawa nung Sharia law at yung customary law and yung our formal laws. Importante yung konsepto ng agency na sinasabi natin, pero lagi nating tinitingnan yung self-agency sa konteksto ng community. Naalala ko yung isang research ng 3-area research noon na ang pag-conceptualize ng kababaihan sa women's rights ay human rights ay hindi as we frame it na universal in the Universal Declaration of in UDHR. Hindi ganon. Ang kanilang konsepto, if we are to translate it, ay hindi dapat, hindi karapatan. Kung hindi, I don't know kung naalala pa ni Judy to nung mga panahon na sana. They frame it in terms of sana. Sana ganito, sana ganito, sana ganito. Hindi, dapat ganito, dapat ganito, dapat ganito. So may pag-uumpisahan kang sana. And I think in many contexts, nag-uumpisa ang kababaihan, ang mga IPs, ang mga indigenous peoples, doon sa sana at yung tension at how do we marry or find a good balance between all these seemingly conflicting and antagonistic provisions ng ating mga batas. Gusto ko ring ibalik yung discussion doon sa sinasabi ko kaninang cultural translation. Napaka-importante, sabi ko kanina, nung role nung academic, nung researcher, nung human rights advocate, nung development worker, kasi tayo yung bridge between government, international funding institutions, international institutions like the UN, the EU, etc., the ADB, and the local communities. So napaka-importante at napakahalaga nung paano natin binibridge yung magkaibang pag-intindi at analysis and framing nung nasa labas at nung mga nasa loob, ng mga miyembro ng community. Kaya wag nating kalimutan yon. Number 3 na gusto kong i-underscore, emphasize, yung nuancing. Ito kasi ang training sa akin sa anthropology at lalong-lalo na si June Brett. Si June Brett na do not overgeneralize. You can only speak for the ethno-linguistic group you are looking into and in that specific barangay or sitio where you conducted your research. There's a tendency for development workers and social scientists and NGO workers to overgeneralize. For example, can we speak of a pan-IP cosmology or framework? Can we even speak of a pan-cordillera culture or ang hirap kasi kahit nga ako sa Mountain Province I make it a point na talagang ito findings ko lang to sa to kasi sa kabilang munisipyo pwedeng iba na yung sitwasyon. Just a few kilometers away, ibang-iba na ang pagtingin. Lalo na kung nasa bandang boundary areas ka. So, importante yung nuancing at yung role natin as academics, development workers, as intermediaries and cultural translators. Yun lang siguro yung masasabi ko at this point.
Thank you so much, ma'am. Actually, maganda nga po yung point na yun na cultural translation, no? And these tensions of perceptions and ideas when it comes to gender and indigeneity, na pagdating sa community, baka magbabago o baka iba po yung pag-intindi, no? And that's why this process of cultural translation is so important. And I believe one question was raised in the chat, Sir Geoffrey, perhaps you would like to expound a bit, no? That perhaps certain labels may not translate over into indigenous communities, and at the same time may supposed conservatism po ba ang elders, so medyo may hirap ba na yung openness sa gender ideas and LGBTQ identities. Perhaps you could expound po on that.
Okay, sige. First, gusto kong sagutin yung unang question on the conservatism of elders when it comes to queer folks, queer identities. Una sa lahat, it really depends, no? It really depends kung gaano yung extent noong nasabi kong factors kanina, nabanggit kong factors kanina in my presentation, doon sa kanilang buhay, on how they view things, ganyan. Definitely there are elders who are open-minded on these things. And patuloy lang ang challenge sa atin is to keep engaging on them dahil eventually they will understand and they will recognize. Kagaya nga nung sabi ko kanina, merong isang elder from Dalikan in Bontoc na over time na-realize niya na even if their children are gay or lesbians, walang masama if they remain to be sound individuals, good individuals who can serve their community. Ganyan. On the second point, doon sa, I think this was Heather's question, na kung meron bang unique roles ang queer IPs noon. Doon according to our research, walang unique roles for queer IPs in the region. Their roles were basically, yun nga, nakakulong doon sa gender na na pinipresent nila bilang sila. So for example, the Linalaki or the lesbians, among Igorot communities in Mountain Province, it is the preference to engage work, usually assigned to men. So agricultural work, heavy work, at iba pa. And then for the binabai, the gay, it's the other way around. They prefer to engage in providing personal care services and operating beauty parlors and the whatnot. So, mas yun pa siguro.
Thank you po. So,
can I say something?
Sige po,
Karin.
Yes po.
Si June Brett kasi maraming kwento yan eh. Kung pwede nga lang i-record mo siya habang nagkukwento siya sa'yo. So in the early part of her career as an anthropologist in the 1960s, ano na yan eh, nagkukwento na siya. Pinento na niya yan sa amin sa anthropology faculty. Na as early as the 1960s, meron ng bakla sa Bontoc. At yung tatay nung itong baklang ito, initially ay ayaw at galit doon sa anak niyang bakla kasi nga hindi pa dahil very rigid or may homophobia, kundi there's no room for kumbaga unthinkable doon sa kultura, saan mo ilalagay nga yung bakla, hindi siya babae, hindi lalaki. This is from the point of view of the elders. At yung pamilya nila ay warrior. May tradisyon ng warrior at warrior yung pamilya nila. So saan mo ilulugar yung kanyang baklang anak? Fast forward 20 years after, bumalik si June Brett doon sa community. And then kinausap siya nung elder, nung tatay, nung ama. Sabing gano'n na, tama ka, ma'am. Kasi sinasabing June Brett, wala namang, hindi nagmamatter kung bakla yan, hindi nag-ibig sabihin masama yung anak mo. Basta kung anong klaseng tao siya, hindi nagmamatter kung anong gender niya, kung bakla ba siya or hindi. Tapos, 20 years after, nagbago na yung pananaw nung tatay. Sabi niya, tama ka ma'am. Sabi niya kay nagkukwento na ako, no? Parang ako na si June Brett, no? Anyway, sabi niya, kasi po, yung anak ko, may beauty parlor na siya sa Bontoc Sentro. At yung kinakita namin sa isang anihan ay equivalent sa ibinibigay niyang sustento buwan-buwan. So ano ibig sabihin nito? Napaka-importante nung economic aspect, nung economic agency, lalo na sa isang lugar na naka-depend primarily sa agriculture, na yun lang kinakabuhay, wala kasing mining, fortunately or unfortunately, walang mining, walang turismo. So agriculture lang talaga. So imagine mo yung isang anihan, equivalent lang yung pinapadala buwan-buwan ng anak niyang may beauty parlor sa Bontoc. So sabi niya, very productive at very useful. Unlike my other sons na walang ginawa kundi uminom at maglasing. So nagkaroon ng openness ngayon itong matandang galing sa isang pamilya na may warrior tradition. So napaka-importante ng economic. Pero at the same time, ito si Jeffrey, no? Joffrey ba Jeffrey? Nasa minority kasi ako. I am really advocating for bringing to fore all these labels, all these identities, all these subjectivities. Kasi pagpunta ka sa area, ibabato sa iyo yan, babatukan kaya anong queer theory kaya anong queer label ka dyan. Minamagkit ako, bakla ako, binabae ako. Diba? So, I am not against these Western labels and these acronyms per se. Pero kung ini-impose natin yan, nang hindi naman sila nag-fit sa local context, may mali doon sa approach natin. Ako, when I started conceptualizing my research, actually, I never thought that I would discover the Minamagkit. I thought I was just going to an area and look for yung counterpart ng bakla tomboy dun sa community. Pinagsimulan ko lang na sa Mountain Province may 3 municipalities that were seemingly more open, more accepting, and there are a lot of bakla and tomboy in the community across generations. Yun ang starting point ko. Lo and behold, actually I didn't want to include the bakla in my study. Kasi affirmative action ako sa women and lesbians. Pero bakit mo i-exclude? Sila yung mas may interesting stories and discoveries. May mga major discovery yun sa akin. Na natalisod ko itong mga minamagkit na ito. At ayun, I was very happy and kung walang pandemic, pabalik-balik ako sa area and I'm friends with many of them. So yun lang, let us be more pragmatic and critical and careful. Kasi baka mawala, lalo nang kailangan nating i-document ngayon, baka mawala yung nuanced, yung local, yung vernacular, dahil we're trying to adopt and impose all these Western transnational categories. Salamat.
Thank you, ma'am. And while we're on the topic po, perhaps you can answer the question in the chat box on the reason for the Minamagkit's preference for the secret sexual encounter before we move po to the next topic of the Q&A.
Okay. My key informants were among the first generations of the Minamagkit. Sila yung mga unang Minamagkit na nag-come out or nag-umpisang mag-come out. They were also the first generation na wala ng ato at wala ng, ulog. Nawala na yung homosocial institutions. Wala na. Yung generation nila hindi nakasali doon. So, sila din yung unang generation na nagka-come out doon sa, nag-explore ng pagiging bakla. But, yung stigma and sense of shame and being outed when they are not ready was a constant source of fear for the Minamagkit. So, ayaw nila na, halimbawa, malalaman nung crush nila na classmate nila na lalaki, na crush nila siya. All the more when they, in their puberty, adolescence, na mag-explore sila ng kanilang sexual identities and sexual practices. Ayaw nilang, kasi usually daw, there were a few cases na yung mga lalaking kaklase nila, papayag sa oral sex, pero kinabukasan, i-chismis ka. So yung fear na paano pag nalaman ng tatay nila, ng parents nila, ng kuya nila. So they would rather have sex with strangers or transient population like tourists, local and foreign tourists who were already in the area, or itong massive deployment of soldiers in the area since the late 1970s. So parang yun nga sabi, pinagtagpo. Nag-e-explore itong mga Minamagkit, lonely itong mga soldiers na ito. So nagkaroon sila nagkaroon ng mga relasyon. I hope I answered the question.
Thank you po, ma'am. And the next topic that was raised a lot in the chat box, no, when we talk about gender and the IPRA, inevitably we run into gender and other institutions. So IP women or queer indigenous persons interacting with other institutions in our society, most notably in government. And someone raised the question on gender and development. So they said that it was mentioned in the morning session of these lectures that GAD, gender and development, is a very cultural concept. No? So women empowerment then may not look the same in different contexts or cultures, communities. And perhaps Ma'am Judy and Attorney CHERYL would like to give some input on this. Yes, go ahead po.
Yes, June Prilbret, aside from being an aunt by affinity, is also, I would say, a mentor. She was the one who got me interested in legal pluralism when I had been attending conferences where she was a speaker. And there's something that I remember asking her maybe 20 years or 30 years ago. I asked her, I told her up front, I think the DAP-I system, the ATO system, these are very patriarchal. They are anti-women. And she asked me, why? Because women are not allowed to go inside the DAP-I. And she told me, you know, you have to understand the reason why women are not allowed in the DAP-I. Traditionally, the men would go to the DAP-I or the ATO to prepare for war, So when they stay there, they have to, parang mag-absorb ng energy para psychologically they will be prepared to go to war. Kasi sabi ko din sa kanya, anti-woman ang DAP-I at ATOR because as a child, I heard that if a girl would go inside the DAP-I, she would suffer from disease in her private parts. Narinig ko yan eh. At hindi lang ako ang nakarinig niyan. Sabi ni Professor Brett, totoo yan na may mga sinasabing ganyan. Pero hindi naman talagang magkakasakit. Kundi, it was a way of keeping women away from the DAP-I. Kasi daw, ang mga warriors at that time, bago sila pupunta na mag-tribal war, kailangang hindi sila soft. And sex daw had a way of softening yung result ng mga kalalakihan to go to war. So later on, when I read na si Manny Pacquiao, yung ating pambansang kamo, I'm not campaigning for Manny Pacquiao, by the way, but I have to mention him. When he was interviewed one time, he said that he would not have sex the night before a fight. Kasi so maybe sex has a way of softening somebody. So itong mga kalalakihan natin, pag pupunta sila sa war, kailangan ang iniisip nila ay, violence. Kasi war yan eh. Hindi pwedeng iniisip nila ang kanilang mga misis. And then after they would go to war, after the war, they would go back to the DAP-I to do some cleansing ritual. So sabi ko, yun pa rin. So bakit sila lang ba't sila lang ang warriors? Why wouldn't they take the women? Sabi niya, hindi rin pwedeng dalhin ang mga babae kasi the society defined rules for the women which were not unimportant. They were equally important. So doon ko nakita na, okay, nag-iiba pala talaga ang kultura. If you are going to use the standards of today to judge the way that indigenous societies look at gender and development, then definitely we would say they were anti-participation of women in development kasi hindi pinapayagan ang babae na mag-warrior, hindi pinapayagan ang babae sa DAP-I. Pero nakikita natin pala na may dahilan yan at kailangan yon to preserve the community. Tapos sabi ni Professor Brett, actually ang mga babae nun, they were also very influential kasi yung mga warriors, yung mga lalaki, because lahat ng mga lalaki would have to go to war, adults. Sabi ni Professor Brett, kinukonsulta nila ang kanilang household before they go to the DAPI and make decisions with the Council of Elders. They have to consult the household, and that would include the wives and the women and the mothers and the sisters. So, totoo na hindi natin dapat ikahon ang konsepto ng gender and development. I am a legal realist. I believe that laws should be interpreted according to the needs of the present. Hindi mo pwedeng sabihin ang interpretation ng batas noong 1900 should be the same sa ngayon, because we know that societies are dynamic, cultures are dynamic. Law is an element of culture, and because law is an element of culture, we should also allow interpretations of laws to evolve. Pati yung mga policies natin about God, what could have been relevant 20 years ago may not be relevant at the moment. Yeah.
Thank you, Attorney. Ma'am Judy, perhaps you would like to give your thoughts on this as well.
Maganda yung discussion ni CHERYL, nanonood sa phone. Pero ang iniisip ko lang sa, and I do believe that culture evolves. So ang measure ng gender and development should always be, I think, ay doon sa empowering. It should be empowering for women and men, but especially as an affirmative action for women. How? Yun yung mag-iiba-iba, depende sa kultura. Ang mahalaga ay meron siyang sense of self, meron siyang sense of power to assert ano yung pangangailangan niya, at mayroong collective na pagtugon dito sa mga pangangailangan ng kababaihan. Yung participation ay napakahalaga pa rin hanggang ngayon sa iba't ibang antas ng decision making. Maski ngayon sa mga consultations that we're having, ang isa pa rin na sinasabi nila ay kunyari sa issue ng FPIC, wala kaming puwang para makapagsalita o para maintindihan ano ang proyektong pumapasok sa aming lugar, at second, mapagmuni-munian namin ano ang epekto nito sa aming community pero sa amin din given our roles in the community. And then the third is dapat meron silang suporta institutionally to be able to speak out and actually actively be part of the consultation. These are some of the measures of development na dapat ay sinusuportahan ng pamahalaan. Unfortunately, hindi natin yan nakikita nga ngayon. Mas repressive hindi nga lang sa kalalakihan at hindi lang sa kababaihan, kundi sa indigenous peoples themselves. Repressive ang mga development paradigms na meron tayo ngayon. So, napakalaki pa rin talaga ang ating dapat itulak sa usapin ng development, but specifically for gender and development. That would be truly empowering for women and young women within the communities.
Thank you, ma'am. And going on a specific example, meron pong nag-message sa chat na on the recommendation mentioned earlier to integrate IP birthing traditions in the medical and healthcare curriculum, what movements and dialogues have taken place between IP communities and CHED? So if Ma'am Judy could, meron po ba na nangyari?
For DLAC, for example, we've had dialogues already. And ang laging sinasabi kasi ng Department of Health, for example, ay devolve na sila, therefore wala silang control or hindi nila hawak kung paano i-implement ang mga health services sa mga local governments. Pero ang inaabangan kasi ay yung tinatawag na Manchen strategy, yung maternal newborn child health and nutrition strategy ng DOH, na malaki sana yung component ng IKSP o Indigenous Knowledge Systems and Practices of Indigenous Peoples. Kaso wala, 8 years na ito, wala tong enough budget lagi. In fact, ngayon, last week we had a dialogue with DOH precisely on this. Ang tugon nila sandali lang, nag-gender and cultural sensitivity training pa ang DOH, at wala ngang budget. So napakabagal nito. Kaya ang mahalaga sana, ang first step ay, while we push for the integration of this, sana i-decriminalize. Wag nang i-implement ang penalties at criminalization ng home births, lalo't higit sa mga indigenous areas.
Thank you very much, Ma'am Judy. No? And napakahalaga nga po, no, to recognize these indigenous traditions that are already existing and are working well for women in these communities, and to somehow recognize this even in the state law or in state policy. So can Attorney CHERYL give some light on that po? Any comment on that po? On things like
yes.
indigenous birth? Yeah.
Yeah, actually, I'm not so familiar sa provisions ng alternative medicine law natin. I forgot what the law is. Pero ang pagkakaalam ko, recognize na ang birthing traditions natin. Yun nga lang, ang hindi yata na firm up dito ay yung parang implementing IRR, implementing rules and regulations. But I support Ms. Pasimio's stand that we should decriminalize yung paggagamit ng mga indigenous birthing methods, kasi in the process, pag may namatay dyan, di ba, alam natin kung anong mga consequences. Again, I go back to what I said earlier. If the state does not recognize the traditional birthing methods, traditional health practices, that would again be institutionalized discrimination. It's structural oppression at best, because we are again saying that the knowledge of the IPs is very inferior to what is the prevailing knowledge. And we cannot claim that. Why? Sa usaping environment alone, we know that 20% of the world population is IP. And the IPs of the world occupy only 5% of the we only have 5% of the world population is IP. Now these IP populations, they occupy 20% of the world's surface. So 20%. Now in the 20%, you find at least 80% of the remaining resources. What does this tell us? It tells us that indigenous knowledge is superior. Why? Kasi ngayon naghihirap ang mundo, anong gagawin natin to conserve the environment? What do we do so that we will not become extinct as a planet because of climate change? And we're trying to go back to the we're trying to harness traditional knowledge. Ibig sabihin, may kaalaman din ang mga IPs, hindi lang sa pag-alaga ng environment, hindi lang sa pag-promote ng justice, kundi pati sa usaping health. Kaya tama, nag-agree ako doon kay Judy sa sinabi niyang dapat irespeto ang mga yan. And like her, I call on the DOH na sana gumawa kayo ng isang legal framework, make it easy for IPs to be able to practice their indigenous practices when it comes to health and birthing. Maganda rin yan na pinag-uusapan din, kasi hindi naman lahat ng manganganak ngayon ay may pera. Ang mahal kaya ng mga anak sa mga ospital. Isang option mo dyan is to go to the public hospitals, but that does not take note of the reality that many IPs are still found in areas that are far removed from the public hospitals. Sa ibang cases nga, wala pang public service na nakakarating sa kanila. So, tama rin yung panawagan ni Ma'am Judy. Thank you.
Thank you po. So we see here no, na just as state law also evolves, no? State policies also evolve, and hopefully they evolve towards being more inclusive of both gender and indigenous people's rights. Now, meron naman nag-bring up doon sa chat na yung flip side naman na what about the dynamism of customary law and cultural law? And na yung example po na ginamit nung audience member ay yung woman bodong holders. So may I ask if perhaps Ma'am Judy would like to comment on this? Perhaps may mga examples po kayong nakita, and even Sir Geoffrey and Ma'am JJ, if meron po silang nakitang dynamism of customary law when it comes to the Minamagkit and LGBTQ in IP communities.
Mag-defer ako kay Jeffrey tsaka kay Prof. JJ muna.
Sige po, ma'am.
Professor JJ, baka
Ano yung question, Karin? Sorry, women bodong?
On the dynamism po of cultural laws. So, yung
Ah.
example po na ginamit ay yung woman bodong holders, na dati mga males lang ang bodong holders, ngayon na may sinamang mga babae. So I was wondering po, even in your research or perhaps sa mga ibang experiences niyo po, may nakita po ba kayong ganon din na evolving ang customary law when it comes to gender, or yun po?
Sorry, hindi ko kasi area of expertise or interest yung bodong. Pero generally, I think if these traditional and indigenous institutions were previously all male and did not allow the participation of women, and therefore, generally, kung meron na nag-evolve yung institutions and systems that perhaps it's the women themselves who created and created the space and the institutions na meron kang women bodong. In the same way na 'di ba sa Bontoc sila yung they created yung sila yung ano bang tawag dito, sorry I forgot, yung elder women, sila yung dahil kapag police and barangay tanods yung nagpapauwi sa mga umiinom na mga kabataan, yung youth, hindi sumusunod. But if it's their mothers and their grandmothers who go to the drinking places and ask them to go home, gawid kayo, tama na yan, last call na, last beer na yan. So wala, mahihiya sila, uuwi. So very creative ang women kasi in creating and finding those spaces. So welcome yan for as long as, kasi iyon nga ang punto eh. If they are able to create these spaces and institutionalize these practices and institutions, galing yon dun sa particular context and dynamics nila. Hindi yan, mas mahihirapan tayo if imposed from outside. So baka ano yan, organic doon. Alam naman natin ang history ng malalakas at very assertive ang women ng Bontoc, lalo na yung such struggle na sa Chico River. Tungkol sa LGBT, ang sinasabi ng literature at ng research ko in the limited area where I did my research, hindi naman talaga, wala kang masasabing. Of course, nandiyan na yung inroads ng patriarchy, ng modernization, and at the same time ng imperialismo, globalisasyon, commercialization. Pero sa indigenous at sa traditional na kultura, na hindi ko sinasabing na stagnant and unchanging, wala ka naman makikitang talagang prohibition na bawal. Except that yung gender roles kasi na napaka-importante doon sa ekonomiya nung lugar, walang space. But when the economic aspects, the economic sphere change, pumasok na ngayon ang mga hindi na lang agriculture, other forms of livelihood. At napaka-importante na pumasok ang beauty parlors in the area. Nagkaroon ng empowerment ang mga bakla, ang mga minamagkit. Nagkaroon ngayon din ng pagbabago sa pananaw sa mga bakla, sa minamagkit at sa gender roles. Kasi nagbabago siya dahil sa sa particular context, hindi inimpose yan ng from the outside. Ang kababaihan na medyo macho or gustong or tomboy ay merong lugar sa ekonomiya. Ang bakla rin ay meron na ring lugar sa ekonomiya. So, nagkaroon ngayon ng openness at na-break mo na dahil din sa openness ng ekonomiya at ng kultura, na-break mo yung socialization doon sa mga indigenous homosocial institutions like the DAPI, the ATO, the ulog and the sorry, I forgot. So hindi na yung heteronormative socialization ay hindi na rin ganon kalakas yung stranglehold o yung hawak doon sa kabataan. So mas may nagkaroon sila ng freedom at saka yung education and migration to Baguio, to Benguet, and to Metro Manila exposed them to various ideas and gender identities.
Ma'am Judy, naka-raise po kayo ng hand.
Oo, napaisip lang ako na nabanggit ko rin pala yan kanina, no, na yung pag-adjust, I should say, ng kultura at ng kustumbre ay dahil na rin sa and I agree with Prof. JJ sa lakas ng pagtutulak ng mga kababaihan. At nakita yon ng community that they have become not just assertive, but they have actual political leverage na sa kanilang pag-occupy ng spaces of leadership dito sa loob ng communities. Tulad ng nabanggit ko kanina, yung sa higaonon nga na indigenous political structure. Ngayon, yung si Bae Rose Undag, after niya na maging commissioner sa PCW, this was way before, pagkatas ng term na doon, nakilala na at the national level, kinikilala ang leadership niya. Ngayon, member na siya ng council ng indigenous political structure nila, ng Lipendagan, na dati ay male-dominated. So, may ganong pagluluwag, pero dahil na rin nga yun sa assertion ng mga indigenous women themselves.
Thank you po. Sir Joff, anything to add po on that?
Well, agree ako dun sa mga nabanggit, no, na yung assertion ng mga kababaihan at ng mga LGBT ay yung isang vital factor towards creating these spaces for them. Yun yung sinabi ni Ma'am Judy na political leverage, iba pa. Kaya parang ang challenge sa atin ngayon, particularly for the LGBTs, is to organize ourselves and yun nga, assert our identity hanggang sa ma-achieve natin, hanggang sa maabot natin yung pagkakaroon ng mga ganitong espasyo at ganitong klase ng pagkilala, no? Mas yun.
Ayun, maraming salamat po. And for my question po dito for Attorney CHERYL, no, in an IP community where they had their own recognized traditional justice system, how do we consider international law on human rights violations? If the IP community does not conform to the law on human rights violations, what could this mean for cultural rights and legal rights in a broader aspect?
Alam mo, when the indigenous peoples dispense justice, they're not really thinking in terms of national law. They're not thinking in terms of international law. They're thinking in terms of what justice is, what the form of justice is as appreciated by the community. So, yung tanong ba ay, is it addressed to me as a practitioner or is it addressed to the indigenous community?
Kayo po, you can address it both ways.
Yeah, so yon, I don't think they're really even thinking about ito ang sinabi ng IPRA, they're not thinking of that. They're thinking in terms of, is this just? Will this promote peace? Will this promote the goodwill or will this enhance community relationships? So I don't think they're really invoking international law or national law if they're deciding cases using the strictly traditional justice system. It is possible, though, that members of customary justice systems in indigenous communities are familiar with national law, they're familiar with international law, and it does not hurt if they will introduce those concepts in the way that they decide or the way that they settle conflicts. So Ano yung, may isang next question doon na I found interesting parang ano yung sabi? Yung second part.
What could this mean for what is the manifestation of cultural rights and legal rights in a broader aspect? So what does this mean po kung ganun?
Well, if we allow indigenous peoples to dispense justice the way they want to, we are respecting actually their right to self-determination. And self-determination is a collective right of IPs, and this is a right that is recognized even in international law. In particular, I'd like to quote the International Covenant on Civil and Political Rights. I'd like to quote the International Covenant on Economic, Social, and Cultural Rights, and a soft law, the United Nations Declaration on the Rights of Indigenous Peoples. In Section 3 or Article 3 of the UN DRIP, and in Article 1 of both the two covenants that I mentioned, nakalagay dyan, all peoples have the right of self-determination. By virtue of this right, they have the right to chart their political, economic, and cultural destiny. Yan ang sinabi. So pag pinapayagan natin ang paglago at pag-advance at pinapayagan natin ang legitimacy ng indigenous justice systems, we're actually recognizing the rights of the inherent right of indigenous peoples to be peoples. Pwede bang i-explain ko rin kung bakit napaka-importante ng paggamit ng peoples? Importante yan because if you are a people, then it means you have the right of self-determination. Actually, sa Philippines, medyo safe ang ating constitution kasi ang ginagamit ICC, Indigenous Cultural Communities. Kasi when the constitution was crafted, this was at the time when states in the world were afraid of using peoples because they thought na pag ginamit daw natin ang peoples, then suddenly IP communities would claim statehood and they would secede from the national territory, which is not really the case. So, ito ay isang yung tanong kanina at yung isinagot ko ay ang isang pangingilala sa peoplehood ng indigenous peoples. They don't have to secede from us. We don't have to allow them to secede from us for us to respect their right of self-determination.
Karen, pwede ba akong magtanong kay Attorney Daytec?
Yes, ma'am, sure.
Oo. Kasi sa practice at paggamit ng customary law, one of the experiences that we had is the enforcement of that decision. It's okay if the issue or the matter at hand is within the community. Pero kapag ginamit yung customary law vis-a-vis a crime supposedly or allegedly committed by someone outside their community, yung enforcement yung problema. To be very concrete po, sa Siocon po sa Zamboanga del Sur, kung saan nagkaroon ng violation ng TVI or Toronto Ventures Incorporated Mining, binugbog ng mga gwardya ang mag-ina na subanen na naglalakad doon sa kalsada na pinave ng mining corporation. They said it was a private road and therefore they had no right to traverse doon sa land lane. So nabugbog at dinala ito doon sa indigenous justice system nila at napagdesisyonan ng Seven Rivers na council that there has been a violation, there has been a crime. Pero hindi naman nila ma-enforce because that would entail police power or para mapanagot ang mining. How does that work?
Thank you for that question. Yung sinasabi ko kanina about legal pluralism, yung sinasabi ko na maganda din na payagan pati murder na isettle using the justice system. Opinion ko yon because I advocate legal pluralism and I have very high respect for the indigenous justice systems as well. But that opinion is not shared by the dominant thinking. Even the Supreme Court is saying na what the indigenous justice systems can settle are disputes, not criminal cases. ang criminal case daw, ang pwede lang mag-prosecute dyan is the state, and that's referring to the Department of Justice through the prosecutor's office. So, totoo na pag ganyan na may decision nga ang justice system pero hindi nila ma-enforce, especially if the offender does not come from the same community. Kaya importante na ituloy pa rin natin ang kampanya para mabigyan ng ngipin ang indigenous justice systems so that even decisions of these justice systems will be enforceable, and that leaders of IP communities can go to the courts for help, assistance, so that they could enforce their decisions. So isang kailangang tingnan natin yan. Totoo yan. I really know the difficulty. But at the same time, may pwede pa namang magawa ang community dyan eh. Kasi ang offender din ay community, di ba? They're member din ng IP or hindi? Outsider. Iyan ang mahirap. Kasi
security guards ng mining corporation.
Yes, yan ang mahirap kasi ang sinasabi ng batas ng IPRA is if the dispute involves IPs. Yan. Pero pag ito ay yan, I think pwedeng magawa na ng paraan, gagawa ang NCIP. In fact, in the DOJ I made some proposals myself. Hindi ko na alam kung ano ang nangyari. Pero if the offender is somebody from the outside, mahirap yan. So I would still tell the community, use the prevailing justice system. Ang tanong nga lang, will it be effective? Alam naman natin how justice in the Philippines works. So you can use this system and you can use another. Yan ang maganda. Pag IP ka, you can use the indigenous justice system. Pag ang mga parties involved are IPs as well. However, if the offender is an outsider, I would say you have to use the outsiders justice system. It's the same problem that's being faced by the American Indians in the US.
Salamat po. Thank you.
Okay, thank you very much for that exchange. No, at this point, I would like to ask our assistant moderators to send our evaluation link sa chat no, before we close out our panel so that our audience and our participants can fill up that evaluation. And just to tie everything together, no, this is a lecture series by a higher education institution po ng UP Baguio. So I would like to bring it back to our questions of research and questions of advocacy. And may mga tanong po sa chat asking on certain aspects of research and advocacy. So may I just ask the speakers one by one no, sa mga experiences nyo and sa mga alam nyo about indigenous peoples and gender, what are the opportunities for research and what are the opportunities for advocacy as well? So anyone can start po. Perhaps we can start with Ma'am Judy.
Let's start the reverse way.
Reverse way po ba? So kay Ma'am JJ, kaya pwede? Yes.
Parang dayaan na nangyayari. Tulakan ng tulakan. Ano nga ba to? Advocacy and research. Okay. Ako kasi, there are always opportunities na for research and advocacy. Ako ay isang I advocate for engaged anthropology and bordering on activist anthropology. Hindi pa ako ganun ka-ready sa activist anthropology. But I always make it a point na importante sa mga taong partners ko sa research yung research problem. Hindi lang siya interest ko, kung hindi, interest din ito ng mga key informants ko. Magkakaroon ng benepisyo yung mga key informants at yung community as much as possible. Hindi lang dahil para kumuha ako na magkaroon ako ng promotion or ma-earn ko yung degree at maging sikat, etc. etc. Pero umabot ako din sa point na tingin ko I'm best, hindi man siguro best, I'm more useful in doing research. Hindi pa ako ganun kagaling pero natututo ako every step of the way in every research that I do. And I am partnering with NGOs na sila yung tingin ko makakapagsulong ng advocacy at nung mas pushing the envelope. For example, in my research sa health ng mga Minamagkit, bakla at tomboy sa Mountain Province, natapos ko na yung research and the article. Ang partner ko dyan ay ang Likhaan Women's Health NGO sa Maynila. And I'm also open to other NGOs na gustong makipagtulungan dun sa research. Kasi hindi importante yung research Yung malinis na research, maayos ang datos mo, hindi lang qualitative, pag i-kombinasyon ng qualitative at quantitative. Kasi naghahanap ang government agencies and international organizations ng quantitative na datos. So, tulungan yan with the NGOs and the POs. Tapos meron kang matinong research para ma-push natin kung ano ba yung ating pagbabagong gustong mangyari sa communities at sa general population, sa kawimenan at sa indigenous communities. So, yun ang role ko. Nakita ko na itong role ko, dito ako mas productive. Therefore, I will stick to this.
Thank you po, Ma'am JJ. And for Sir Joff?
I agree with Professor JJ nang sinabi niya na our research problems should work towards the resolution of the problems ng mga stakeholders when it comes to research. Ganyan. So, maraming opportunities na pwede nating gamitin, maraming mga bagay na pwede nating we can focus on research on, and then eventually mag-work towards the mag-serve sa interest ng mga stakeholders dito sa indigenous communities here in the Cordillera region. For one, nababanggit kanina yung health. Maraming health practices pa actually ang pwede nating i-research. Traditional health practices, and then how we can amplify them and enhance them to complement itong existing healthcare system natin. And then I think ang isa pang ongoing research ngayon is yung indigenous traditions on mental health processing, psychosocial processing. Ganyan. So how we can use traditions to alleviate mental health issues, ganyan. So, yung mga ganyan marami pang mga ganyang bagay na pwede nating i-explore along the way, as long as it will serve the interests of the many, particularly the indigenous communities.
Okay, thank you, Attorney CHERYL.
Yes, thank you so much, because I'm in the company of researchers, and I no longer have time and opportunities for that. I'm glad you're there to do the research for us. I work at the level of international policy making, and I believe that policies should be grounded on research. Maraming mga polisiya ang hindi nag-work. There are policies that don't work. Why? Because they were based not on realities, which have been established through legitimate researches, but they were simply hinugot sa hangin, or they were crafted in ivory towers. So i-push nyo lang yan, mga na mag-research ng mag-research. Ang isang magandang i-research din siguro is women, indigenous women in the diaspora, or tsaka yung indigenous women as overseas workers. Baka walang masyadong research na nakita natin dyan. Tapos yung opportunities for advocacy, I think everything should be an opportunity for advocacy. Anytime is an opportunity. For example, sa work mo, there are spaces where you can put the concerns of indigenous people. Sa akin, sa araw-araw, may nakikita akong mga opportunities for indigenous peoples. In the International Labor Organization, lagi akong tumatayo, and I would always ask, inisip ba natin ang mga IPs? How will this affect the IPs? We are creating jobs by inviting investments into their territories. But what benefits are there for them? So yan, lahat ng opportunity gamitin natin.
Thank you po. And now to Ma'am Judy.
Siguro I'd like to be very specific where I'm coming from. So we're not a research organization, and so I'm so excited to hear ang iba't ibang mga initiatives then on research. But we of course work closely with Anthro-Watch and other women's organizations doing research. For us, we're entering into a new strategic planning, and for LILAC, ang isa po talagang interest namin ay ang itulak yung reproductive self-determination of Indigenous women. And so we have been wanting to, but I guess we don't have the academic capacity as of now, and we would welcome guidance and support from you, Karen, and the others here, to dispute the no home birth policy and this state discriminatory policy of the government. And so to be able to do that, we want to document Indigenous home births na para ipakita talaga evidence-based na yung risgo ng pagnganganak sa bahay in an Indigenous way is lesser than the risks for Indigenous women going to the very far, unavailable, inaccessible, facility-based birth centers. And so that's one research talaga na gustong-gusto namin gawin na hindi kami makaalagwa. And it's the same advocacy opportunity that we would really like to push, the reproductive self-determination. Ang Commission on Human Rights have already submitted in their CDOR report in 2016 ang tungkol dito sa no home birth policy, but it has not really pushed DOH or DILG to work to address this. And so that also could be a welcome support from those who have asked here, and for those who are willing to take part in this advocacy. Siguro last na lang, for an advocacy opportunity we should push for a national national census. How many Indigenous peoples are there? We still don't have that number. And so if we don't have that number, the Indigenous peoples are still invisible to the policies, to the plans and programs of the government. And so let me just take this opportunity to thank you, and I really look forward to having more interactions with the groups and individuals from this forum. Thank you, Karin.
Maraming salamat po, Ma'am Judy, and to all our panelists. Salamat din po sa ating mga participants and audience members. So we'll just have a short closing program po, so I hope you stay with us until the end. This session is also the last of our CSS lecture series, so allow us to say goodbye properly for the month of October. And to formally give our closing remarks, may I hand it over po to Prof. Jose Matthew Luga, Faculty of History and Chair of the CSS Lecture Series Committee. Sir Matt?
Thank you po, Prof. Karin, for the introduction. So, yeah, let me give just a short closing remark. This 3-day conference entitled IPRA at 24, Charting Developments in Philippine Indigenous Peoples' Rights, aimed to critically examine the dimensions of Indigenous peoples' rights and identify areas of partnership and collaboration on the promotion of Indigenous peoples' welfare. The first session on Indigenous languages and the FPIC by Professor Joao Paulo Reginaldo, Dean Jimmy Fong, Mr. Scott Saboy, and Mr. Rocky Jake Ngalob presented their case studies and the challenges that they have encountered when conducting language research in Indigenous communities. The process of acquiring free prior informed consent, the need to disclose the goal of the research to the entire community, and the ethics of maintaining good relations between the researcher and the community. The second session on the implementation of Indigenous people's rights in the education sector by Ms. Maria Lurie Victor, Ms. Marites Talaman Gonzalo, and Dr. Edgar Tomino broached the history of exclusion of the Indigenous peoples in the formal education system, the actual experiences of implementing Indigenous people's education on the ground, and the need for further inclusion of Indigenous knowledge systems and practices into the IP education system. The third session on appropriation, attribution, and Indigenous Peoples' Cultural Rights by Dr. Annalyn Salvador Amores, Mr. Fernan Talamayan, and Dr. Edwin Antonio, on the other hand, emphasized the challenges involved in the recognition of Indigenous peoples' heritage, particularly the commodification and the need for appropriate recognition of the IP's traditional practices, such as tattooing and performance arts. Building on this challenge of non-recognition, the fourth session on Indigenous Peoples' Rights and Development by Professor Mylinita Peñalba, Professor Hendrix Bongalon, and Mr. Kevin Constantine Fonseca focused on the progress we have seen in IP rights and development, largely thanks to the work of local leaders and IP activists, though they have all agreed that there is still much to be done to bring more equity and justice to IP communities. Finally, our last session, which ended just now, on gender and Indigenous people's rights, of attorney CHERYL DAYTEC-YANGOT, Ms. JUDY PASIMIO, JOSEF LARUA, and Dr. Jennifer JOSEF, provided the needed focus on an equally marginalized and vulnerable sector of the Indigenous society, the women and the members of the LGBTQ plus community, particularly the condition of these individuals, the intersectionality of their different identities and social roles, and the challenges of implementing Indigenous rights vis-a-vis their rights as members of the nation state. Looking at each session, which was covered in this 3-day webinar, I believe we have successfully addressed the goal we have set out to achieve. This would not have been made possible without the time, effort, and knowledge that our speakers have so generously imparted with us. Thus, on behalf of the organizing committee, we would like to thank you all of our speakers. Equally significant in the hosting of this webinar are the people behind the organizing committee. We would like to therefore thank the Chancellor of the University of the Philippines, Baguio, Dr. Corazon L. Abansi, for supporting this program, and the Dean of the College of Social Sciences, Dr. Lea Iabayao, for leading the organizing of this event. We would also like to thank Mr. Jose Kim Alvaro, Don Oliver Alebin, and Ms. Mary Rose Wadsilang of the Systems and Network Office for their technical support, and Ms. Maggie Fawayan, Mr. Nicanor Hermono Jr., and Noel Diaz of the Dean's Office for their administrative support. We are also thankful to the members of the Lecture Series Committee for moderating and assisting in the implementation of this 3-day webinar, namely to Professors Gratian Miklay, Vladimir Kevin Bumatay, Olivia Mendoza, Dana Aduna, Ben Carlo Atim, Jaraya Gray, Verna Liza Bautista, Khadija Bari, Mayumi Teves, and Herald Canoy. Thank you as well to our co-organizers for this event, Professor Karin Bangsoy and Ms. Joy Pahenago, Convener and Research Assistant of the Kasarian Office respectively, Director Tala Salinas Ramos of the Cordillera Studies Center, and Director Annalyn Salvador Mores and the Misea Cordillera. Thank you for your continued support. Finally, we are most thankful to you, our participants, for your attendance and very active participation in this 3-day webinar. We are thankful for your overwhelming support to Indigenous people's rights. We hope that the learnings that you have obtained from this event will continue to inform your work with your respective communities and will have enriched your understanding of Indigenous people's rights in the Philippines. We look forward to seeing you joining us in other future College of Social Sciences lectures. For future updates on our upcoming college webinars, please feel free to follow our social media Facebook page, UPB College of Social Sciences. Again, good afternoon, and thank you very much to everyone.
Maraming salamat po, Prof. Matt. And we formally end our CSS lecture series. Maraming salamat po. We will end with the singing of UP Naming Mahal and credits to UP Tinig Amianan for recording the Pambansang Awit during our opening and UP Naming Mahal for this closing program. So Sir Don, Sir Kim. Yeah.
Maraming salamat, Karin. Matthew.
Thank you din po, ma'am.
Thank you din po, Dean. Salamat din po sa mga speakers po.
Salamat sa ating mga speakers.
Ay, natapos din!
Oo nga.
Congratulations, Ma'am JJ.